Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican for his nervous lobby.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for crumb's sake.
Hello, welcome to the Court of Public Opinion. I am the Recovery Addict. Good to have you here. Just trying to figure out which buttons I want to use today. It's not that one. Maybe a little of this one. There we go. I'm really liking the dual mic setup. It's working for me. Hey Siri, turn on my lights. There we go. You can't see it, but I can, so it's different. Good morning. Happy Friday. Happy Friday. We made it all the way to the end of the work week. Y'all are amazing. I'm just a little chat and I want to be on the screen. Did I make that one? Who says that?
Hello?
Procedural matters, and unfortunately you have not.
Everyone's lights turn on. The power grid across the nation suddenly took a hit as we all turned on greeners. Was that you? I'm pretty sure. I mean, that's creative. I like it. But I'm pretty sure I did not type that. So, all right. Welcome, and especially welcome to Fran Fitzgerald, who's first in chat again today. Congratulations, Fran. You being prompt and punctual, like you are, has earned you a punishment. Everything IP related worldwide is your responsibility for the rest of the day. Good riddance and good luck. Shelly Small, I saw this as we were just starting. I'm so sorry to hear that about your grandson, 2-day-old grandson, rushed to the hospital. Well, hope everything goes well. We'll be praying for you and them and him. I believe it's a him, grandchild. I think it's a grandson. All right. All right. Please let us know. Keep us updated on that. Gurley Jones, apparently I've been here for 5 months already. Apparently. Yeah. You remember that little guy from the state fair? The kid who's like, so apparently. That was the funniest kid. I wonder where he is now. Gurley Jones, 5 months is wonderful. Thank you very much for being here. Appreciate it. We've got a couple other things I need to pop up. Well, Lizzie Yordi. Back in green. Woohoo. Happy Friday, fam addicts. 34 months. OG. That's awesome. Let's see. Grandpa plays a Powerball. Yes, that's him. Noah Ritter is now 17 years old. I hope he made like bajillion dollars off that video because it was hilarious. It's just like it's corn kid. 2 months more till red, Lizzie. That's going to be awesome. Tumwater Troy, 31 months on the jury. OG. I was first in seat. I must be recognized. Says Tumwater Troy. Tumwater Troy, thank you very much for being first in your seat. You were prompt watching for the commands. And Noah Ritter, what a kid. And then there's the Star Wars kid, right? Where's he? He's the kid who snuck into the drama room at the high school and recorded himself waving like a broomstick around like it was a lightsaber. And then his friends found the tape and published it online, and it went hugely viral. Like it was like the first viral video I can think of. Ghislaine Raza, is that his name? Man, I hope he's either like a stunt double for a stormtrooper or something. I hope he went somewhere in life that he's really happy about. All right, Lizzie, good news. Good news for you. You can't lose your run. Unless you change your account, unless like you delete your account and make a new one. If you are a member 1 month and then not for 5 months and a member for another month, that's month 2. There's no such thing as resets for gaps. So do what you need to do for sure. Thank you very much. All right. Rest in peace, Daryl the gambler sheets from Storage World. Oh, I heard that. That was sad. It was sad to hear that he passed away. And the situation, that's terribly sad. Folks, if you're not in a good headspace, if you talk to somebody, let somebody know. Seek help. There's nothing shameful about saying, hey, I need help. Please reach out for sure. All right. Brenda Meyer, member for 31 months. So happy to be here. Can't believe it's 31 months. 31 makes you an OG. Goes very, very fast. It was just the other day we were watching Daryl Brooks together, and I didn't have a goatee. So, yeah, you don't lose your time. That's wonderful. Let's see. Let's see. Online bullying and stalking. Yeah, crazy stuff. To everyone who's been affected by some tornadoes, what was that? Was that Tennessee yesterday? Oklahoma? I don't remember the state they were in. Please stay safe. Hopefully you're all safe and following all the appropriate things, because I like Ryan Hall, y'all. Love him. He's probably one of the best. I'm wearing my Weather Watch shirt today, but he's probably one of the best online streaming weather watchers there are. Love how he does it. Love what he does. Love that he's a nerd in tech like me. And but I sort of also don't like it when he goes live, because he goes live when there's problems. So when he pops up on your feed, it's worth clicking the button just to make sure you're in a safe area and follow the instructions. YouTube up to the premium price? Oh man, bummer. I'm sorry. Make sure you do it on a computer, not on an iPhone. It's cheaper that way. All right, we have some birthdays today. Thank you very much for the birthday command, Judge Fleischer. And we also, oh my goodness, yesterday we had one, just for the record. Remember yesterday we had one birthday. Today we have Krista OG, Jonathan, Julia, who's Texas girly, Katie Bug, L. Teddy, Lacey, Leslie, Little Miss Greeners. That's awesome. 14 years old. Happy birthday, Little Miss Greeners. Misty, Shelley Stone, Ashley Selzer, See Clearly, Natalie, and Tom Taz. This is going to be a mouthful. Okay, so right here, this is the break. So all these ones are today. This is my understanding from what I've learned about mod speak. This is today, and this is tomorrow. So we're going to break it up that way and try to get all these Krista OG with the lightning, which I love. Shout out to the Maya trial. All right. Are we ready to sing? I guess that's the first thing to do, right? Those are some sharp S's. Someone's going to object, I'm sure. That's a reference to the Maya trial where sharp S's were. Yeah. Anyway, all right. I almost see what the outro said tonight when you go home. Let's do this. Wherever you are, if you're able and it's legal, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. We're going to sing happy birthday to these fine folks. I saw that EDB donated $15,000 for the victims of the tornado. That's awesome. Shout out EDB. Happy birthday to you. Happy birthday to you. Happy birthday, Krista OG, Jonathan, Julia, Texas Girly, Katie Bug, El Teddy, and Lacey. Happy birthday to you. We only got that far of verse 1. There's just so many of you. It's all right. We have more verses. We can do this. Happy birthday to you. Happy birthday to you. Happy birthday to Leslie, Little Miss Greeners, Misty, and Shelley Stone. Happy birthday to you. Now the next one. Happy birthday to you. Happy birthday to you. Happy birthday, Ashley Selzer, See Clearly, Natalie, and Tom Taz. Happy birthday to you. I'll take this interlude to rest That's a lot of names. Happy birthday to all those who are celebrating their birthday today. Happy birthday. There are many wonderful days, but today is your special day. And I realize there are a million places it could be and a million people you could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor, the joy, that is ours. Hopefully we can turn that back to you, make your day just a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, and Bob Evans, and Cracker Barrel. An extra "and" in there. It's like 2 Oxford commas. I'm pretty sure that's not a thing, though. You can't use them like parentheses. Just throw them in wherever you want. Whew. Happy birthday, folks. Happy birthday to everybody. As the birthday song continues, the party doesn't stop. Congratulations, all of y'all, for celebrating another trip around the sun. It was an epic list. Thank you very much, mods, for making that happen. It was beautiful as well. All right, drum solo for the big finish. If you don't play, air drums work. Josh is like, I'm done for the day. Hang on. Katie Bug says, also my son's best friend, Trevor, and rookie phenom for the Pirates, Connor Griffin. Go 424. Trevor! Happy birthday to you. Happy birthday. Happy birthday, Trevor. And Connor, you got to show up. We need you to be here. We'll sing to you if you get here. Somebody shout out if Connor Griffin shows up in chat. I'll sing a special verse just for him. But way to go, rookie phenom, Connor Griffin, also birthday. I think we got everybody. That was so exhausting just to listen to. Yeah, we're trying to dodge the landlord-tenant today. That's our goal. We're trying to dodge the landlord-tenant stuff and find a couple other cases. I think we've got a little right here. Let's see if we can go right here. Hang on one second. And I have some reading to do as well. Some light reading.
She's intending on retaining counsel. He's very well known and highly respected by at least me. And Judge, I believe that she wants to defend herself on these charges going forward, so she will appear.
Where can I be? Can I be down here in the corner, ma'am?
Okay, I see something in 2024 out of 48 driving alcohol-related offense for the past.
That's not good.
What are her ties to the state of Michigan? Why was she in Alaska? What are the ties? Is she permanently residing here? Does she work here?
Ms. Tututka, it's true that you now permanently reside in Michigan, correct?
Yes.
Okay. Are you employed in Michigan?
Yes.
How long have you lived at Hill Circle Drive?
About 3 years.
Why were you filing a name application in Alaska then for a name change?
Judge, I don't know if it's relevant.
Were you living in Alaska? Were you living in Alaska last year?
I was living there for 6 months out of the year for the past 3 years.
Okay, so you reside in Michigan part-time?
Yes.
Are you a seasonal person? Like, do you move with
Snowbird?
Do you relocate based on the summer or the winter?
Just based upon my job as a marine biologist, I do work seasonally.
What do you do?
As a marine biologist and
marine. Are you saying marine biologist?
Yes.
Oh, okay. That makes sense. Okay. And so you do work in Alaska?
Yes.
Okay.
In the winter, I come back to Michigan.
Okay. And when you're in Michigan, where do you work?
For the past 3 years, I was working at Cranbrook Educational Community as a ice hockey coach.
Okay.
Marine biologist / ice hockey coach.
And do you have family here?
Yes, I have a mom.
Where does mom reside?
Birmingham.
Okay.
Birmingham.
Okay, I think there's sufficient ties to the state of Michigan.
Thank you.
I'm not concerned that she's going to leave. Okay, Mr. Angot, I cut you off. We're speaking about bond and bond conditions.
No, Judge, I think I've said enough regarding that. Again, I just reiterate, I think a personal bond is appropriate here. If the court is, go ahead.
Keep going. No, go ahead.
If you're not willing to do that, Judge, I'd ask just to keep it a low money bond.
Okay, I need just a second to look at the location of where the allegations took place, because I'm going to write some bond conditions relating to that. So if you'll just give me a minute, please.
Thank you.
Is 6 months in Alaska long enough to get the credit? Like every Alaskan citizen gets, they get some money every year, right? It's like they sell all the oil and then they get some money sent to them. Is 6 months, is that like the threshold? I live there for 6 months so I can get the money and then I move out. Asking for a friend. Actually, I have a friend. I should probably call him. I've got a friend who just moved to Alaska. How long do you have to be there before you get the free money? They do actually pay you to live there. It's not enough to survive there. Let's see. Alaska residents must be residents for the entire previous calendar year, intend to remain and not claim residency elsewhere. Okay, but does 6 months out of the year make you a resident? That's what I'm saying. You can be somewhere else and still live in Alaska, right? You smell what I'm stepping in? Six months and 1 day. She was so close. She was so close. Had she stayed one more day, she would have made the limit. You have to live in Alaska all year long. What if you spend exactly 6 months in each state? Ooh. This is a question you want to ask your tax advisor. In this segment, R.A. ponders defrauding Seward's icebox. There's no way I'm ever going to live in Alaska. Mrs. R.A. doesn't like the cold. And I realize there are some nice warm areas of Alaska, especially when you get down to like the Washington area. Alaskan bush people got in trouble for that. Did they? Have relatives that live in Alaska. It's not as cold as you think it is in Alaska. I know, but it's really cold. Isn't there a place called Nome, Alaska? I think that's where my friend moved. I think he's in like Nome. It's like the furthest north group of igloos. I don't know what they are. I'm sure they're permanent houses, but it's basically in the Arctic Circle or something. That's where he moved to from North Carolina. Where we got snow, we got 13 inches of snow this last year. And if you add up all the 6 years before that, we've had 16 inches of snow. So he's in for a change. Did you see out of Boston, a lawyer, special prosecutor being arraigned on charges of threatening to harm a healthcare worker who wouldn't gurney him to his car? What? I need a gurney to get to my car? If you need a gurney to get to your car, you probably shouldn't be driving. Maybe you should maybe go to the hospital instead of your car. Says you can't be a resident of any other state, though. Isn't she also a resident of Michigan? No, she's just here part of the year. She's a visiting out-of-state worker. When we were in Alaska in July, it was 40 degrees. In my mind, that's chilly. That's sweater weather for sure. That's cold. And then the sun doesn't come up either, so there's that. Or it doesn't go down, depending on what part of the year it is. Crunchy Frog's like, come on, I'm sitting here freezing in Florida today. It's definitely cold in Alaska. Ken Mello. I wonder if there's going to be a case on that one. Is Attorney Mello from the Karen Reed case? Really? Went to Alaska last July, and the people that lived there were angry because it was warm. Warm was 60 degrees. I think it's Jersey, like a Jersey cow. There's, Mimi, generally, I'm fascinated with what people with limited mobility are able to accomplish, and I'm not trying to diminish that in any way. We got had many friends growing up. That was one of the coolest things I got to see was the way a van can be customized to allow someone with who's paralyzed or has limited use of their arms to drive. I mean, seeing somebody drive a van with full hand controls it blew my mind. It was just awesome. You know, I don't know why, because we've been doing it on game controllers for years, but it's just really cool. But if you're not able to, if you need help to, I need a hospital bed to push me to my car, then I'm concerned a little bit. Got to be careful. Court watching is so boring. Is there a trial we can watch? Court watching is a trial.
Okay, the court is still on case number 2501.
This is how things go to trial. This is the process they used to get there.
The court is setting a $10,000 personal bond with conditions as follows.
We start our next one on Monday out of Ohio.
There she is. Ma'am, you have to personally appear for an exam, arraignment, trial, and or sentencing or any probable cause conferences. You shall abide by any judgment, enter in this case, and surrender to serve any sentence imposed. You are not to leave the state of Michigan without permission of the court. You are not to commit any crime while released. You shall immediately notify the court in writing of any change of address from Hills Circle Drive in Waterford Township or the phone number ending in 1082.
I'm sorry, did she say Hell's Circle?
You shall be...
Who named that? I'm guessing their neighbors
not have
awful.
Any contact with Shemaine Hunter or Matthew Hunter. You shall not enter...
No hunters at all.
In Matthew Hunter's house. And you shall not enter upon the premises at
whatever address. It's probably also Hell's Circle.
You shall not do any banking at Chase Bank.
Thou shalt not bank at Chase Bank as well. So lots of commandments for her. Regulations. Chase Bank is out.
I'm going to have you check in with pretrial services 1 time per week. And defendant must contact pretrial services on or before April 28.
You got 4 days, ma'am.
2026 at 3:00 p.m. to set up supervision.
3.5.
And we'll set this matter for a probable cause conference. Ma'am, that will be set no less than 7 days, no more than 14 days from today's date. Those are usually on Fridays. And we're going to set this matter for a preliminary exam. And counsel is not being assigned to you because of the representation that you are retaining counsel.
Hire a good one.
Okay, with respect to Miss Harrington's arraignment, is there anything, I'm sorry, Miss Tutka's arraignment, is there anything further requested or required of the court?
Nothing further, Your Honor. Thank you.
Do you have a Michigan driver's license, ma'am, or do you have a Alaska driver's license? I can't hear you. I'm going to have to ask you to unmute. Sorry.
She said Michigan, but I agree. It should be on the record.
Okay, ma'am. Do you have a Michigan driver's license?
Yes, I do.
You shouldn't. Okay. Unless you're a resident of Michigan.
On your driver's license in Michigan, does it go by Tutka or Harrington?
Tutka.
Okay, thank you. All right. Is there anything further requested or required of the court on behalf of Ms. Tutka on this case, counsel?
Nothing further. Thank you, Your Honor.
Okay, thank you. You may leave the Zoom. Wait, Mr. Angott, we don't.
Yes.
That's going to be after.
Is it?
We have a Berkeley.
Okay. You mean what? You want to do it? Is it ready right now?
Ma'am, you didn't turn it off. We're still live.
Okay, we do have a person in Berkeley who is in custody, but is it a bench warrant case? Because it says Winburn.
Yes.
Well, she's at the police.
Okay, so when would you like to do this?
How about can we in hour?
Do you want to handle this one in a half hour, Mr. Angot?
Sure.
Okay, it's Terrell Elam, Elam. And the gentleman has never been arraigned. It's a 2016 case, uttering and publishing.
Got it.
Okay. So
Okay.
if you can leave and come back, that would be great.
Okay. Thank you.
Okay. Thank
Uttering
you.
and publishing? I guess that's a crime. Thou shalt not utter and publish. All right. Are we done with this one, ma'am?
I want to look at this. I'm not quite done. All right. Now we have all informals, right? Oh no, Patrick.
Patrick, where's Patrick?
We have the interpreter
Oh,
should be present.
Okay,
with
where is
Mr.,
the interpreter? In the breakout room?
Fall, I had texted you his updated mailing address.
Had a lot of fun on the podcast last night. Hope you guys didn't miss that. If you did, you can watch on the replay. We're going to keep it available for you just for a limited time of forever. So, let's see. Thank you, Josh. Going to jump down to Scott McAfee.
Visited the property. She connected a section to it in the front to totally enclose her backyard with her own fence. And that was done sometime in 23, we believe, 2023, before all this started. So it's our argument based on that memo that certainly the collateral agreement that was entered into by the prior owners of the property passes to the new buyer, Ms. Martin, and she is bound by it because it's an agreement to allow a fence to be in the location that it's in. So it runs with the title. And that's what that last memo deals with. Thank you, Your Honor.
All right, thank you. So I'll be on notice and can get into that either upon appropriate motion or on the conclusion of the evidence. Anything else to take up on your part in before we would start testimony?
No, Your Honor.
Okay. All right. Then.
Well, one
okay.
I'm sorry. I do have a notebook of all our exhibits. That's
Is it both sides?
prepared. I have a pad. I sent them a copy, but I also have another copy for them for when I cross-examine Ms. Martin. But I do have a notebook.
Are banished
they've all been
from the
admitted
state
now.
of Georgia.
So I would like to give it to you.
That'd be appreciated.
Yes.
Is this a joint collective, all the exhibits, or this is just the
Fine.
just respondents? Okay.
This is how he sounds when his mic isn't overmodulated.
You got it.
Yeah, we have the same.
We'll take it. Thank you,
We'll
sir.
Take it.
Thank you.
All right, and last thing is a matter of housekeeping. I think I'm familiar with the contentions, the allegations, the basic facts. I don't need anything in by the way of an opening statement. I think we'll get right into the evidence. I also think that it's in. I want to make sure that we finish this today, and to that end, I know the parties have provided time estimates. I think that, again, knowing the nature of the claims, I think the witnesses that are planned to be called, Mr. Klein, is it still 3 witnesses on your part?
Just 2. So the surveyor who's on Zoom, Miss Martin, I guess myself for attorney's fees that we.
All right, that's if we get there. So two witnesses, we'll say, for case in chief, kind of phase one. And on your part, Mr. Miller, one witness?
Randy and Cedric.
Okay, two witnesses. All right, so to that end, I think right now I would impose the time limitations, again, taking into consideration the estimate of time that's been given, the issues, the complexity of the issues. And I would set that time right now. I'll keep it in live display up here on the clocks, but it would be, I think it would say 2 hours for each side right now. And so when your witness is testifying, the clock's going down. If there's an objection, I'll pause it, play timekeeper if it's an extended objection. If it's a short one, I can roll on. I'm not going to time it or stop it just for that. And then when it's cross, flip sides, and then your clock starts going down. And at the end, if you run out of time after 2 hours, the expectation would be that that's when you rest. If you need more time, you can move for it. And I'm going to take into consideration exactly what you need with that extra time, how much extra time you're asking for, and how you use the time that you were given. So if, for example, we were repetitive in the questions or got into tangents, then I might look on that less favorably for extra time. So we'll have petitioner in red, respondents in blue, and it'll be counting down from 2:15. Any questions on timekeeping, Mr. Miller?
Yes, Your Honor. Does the cross-exam include my time?
It would. It would.
It would be, he would be able to take up my 2 hours?
No. Your directs and your crosses are your own time. So no, he can't wind down your time.
Okay.
That's your own. When you're speaking, it's your time.
Got it.
Any other questions about how that'll work?
No, Your Honor.
Okay. Then unless there's anything to take up, we'll go off the record for a moment. Let me check in with my criminal attorneys. I saw Ms. Foster walk in.
I run to the bathroom.
Absolutely. I think we'll go off the record. And again, this is your chance to try to streamline some more things or have any final conversations you need to.
Do you need to clear anything from?
No.
Okay, thank you.
That you can hold in place.
You're comparing apples and orangutans here.
I'm not sure what this is.
Oh, I'm sorry.
It sounds like it might be the argument over whose yard belongs to who.
Ms. Foster, we ready?
Yes.
I'm ready.
Okay, what do we want to take up first?
Let's do Mr. Thomas first. He's on Zoom, so we need to admit him.
All right, so do we have Mr. Thomas on Zoom, and can we add him to the screen, please?
Where you at, Mr. Thomas? Here, let me get a little bigger so I can see myself.
Judge,
Yeah.
can you give me a second? Let me just.
I'm going to be right here, so.
You be where you want to be. Have some witnesses to call. If the issue that was just briefed to the judge is the same one, what we have is some neighbors fighting over some yard, some property that the previous owner apparently let the other lady have. But the new owner says, nope, that's deeded to me. So for tree branches over the other property. Oh, goody. I love a good neighbor battle.
Need to say that a little louder. All right, we have Mr. Thomas with us. If you could come on the video, sir. You have his phone number? You might want to give him a call.
Can I have the indictment, please? The indictment?
Hello. There we go.
Okay.
Okay.
Do I have your permission to sign the indictment on your behalf?
You want to do Khadijah right next as well? I'm going to keep it.
Jesus.
Give it to me when you're ready.
Can you turn that microphone on? That might be a problem. He's not hearing you.
Yeah, I can't hear anything.
There you go. Can you hear me now?
Yeah, I can't.
Yes, sir.
Do I have your permission to sign the indictment on your behalf? Either
Yes.
that or you can be here and sign it.
Yes, you can sign it.
All right, thanks.
These
Mr.
are the
Thomas.
options. Can we begin, Judge? Or is the time going already?
Dutch, do we have a Mr. Levy in the waiting room on Zoom?
No.
Okay.
Order on. No, that's not.
Oh. No?
He's on.
It's good?
It's on.
Okay. All right. We all good?
We are, Judge.
Okay. We're on the record now with 26 SC 001 319, State versus Rontarius Thomas. Joining us by Zoom, his counsel, Mr. Pitts, and the state through Ms. Foster is here in court today. Mr. Pitts, any objections to proceeding virtually?
No, Your Honor. In fact, we requested it.
And you have permission to sign the indictment on his behalf?
Mr. Thomas gave me that in open court this morning.
All right. Mr. Thomas, you can hear me all right?
He is muted.
But
Yes, sir, I can hear you.
Still hear.
All right. You can keep yourself off mute. And we'll just really try to speak up and into the microphone and maybe really turn up the volume on your phone. So I'd like to be able to see your entire face. And at any point, if you can't hear us, just interrupt, ask us to repeat. And if you need to speak with your attorney privately, just let us know, okay?
Yes, sir.
All right, Ms. Foster, again, speaking up for the microphone, if you could swear in Mr. Thomas, advise him of his rights.
Can you please raise your right hand? Can you hear me?
Yes.
Okay. Do you swear or affirm the testimony you shall give at a matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand. Could you please state and spell your true, correct legal name?
True and correct.
RONTERIUS. Thomas, THOMAS.
Can you also
Are you
hold
at this
the phone
time
still?
taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone to school?
26. I now have graduated high school.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses on the
What's he
indictment?
looking at?
Count 1, aggravated assault. Count 2, terroristic threats.
Whoa.
Count 3, possession of a firearm during the commission of a felony. Count 4, possession of a knife during the commission of a felony. And count 4, obstruction of a law enforcement officer.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you can have a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with your attorney's services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes, I am.
And have you reviewed the indictment in this case?
I have reviewed it. We waive reading. I know of no defects.
Thank you. Mr. Thomas, were you arrested on these charges?
Yes, ma'am.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Mr. Thomas, do you understand that you're entering a guilty plea to the following offenses? Aggravated assault reduced to disorderly conduct, which carries a maximum of 12 months. And count 4, willful obstruction of law enforcement, which carries a maximum of 12 months. Your Honor, the state will be no processing count 2 and count 3.
No pros on 2. Looks
Do you
like he's getting
understand,
a
Mr.
deal.
Thomas?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to?
Yes, ma'am.
Do you understand this negotiated plea of guilty, which means the state will recommend to the court a sentence of 12 months probation?
Yes, ma'am.
Count 1 and count 4 will be ran concurrent. The special conditions will include no weapons or replicas of weapons, 40 hours of community service, mental health treatment, no further violent contact with the victim.
Yes, ma'am.
I'm sorry, mental health evaluation and treatment if necessary, no further violent contact with the victim, a family intervention course, no guns or drugs unless a valid prescription, and no further violation of the law.
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand the general conditions of probation?
Yes, ma'am.
Do you understand if you violate any laws or conditions, the court could bring you back for a revocation, which means you could spend additional time in custody?
Yes, ma'am.
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand if you are charged with a crime in the future, this plea may be used to enhance sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you are currently on probation, your probation may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there will be from a conviction following a trial?
Yes, ma'am.
Do you understand by pleading guilty? I apologize. Do you understand that you waive any and all defenses, including any mental health defense, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? I'm going to say them one at a time to make sure you understand. The right to trial by jury, the right to remain silent and not incriminate yourself, the right to see or hear the witnesses against you and to question them, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, which means the state must prove you're guilty of each charge beyond a reasonable doubt, the right to testify on your own behalf or remain silent, and the jury will be told they cannot use your choice against you, the right to present other evidence of your own and call your own witnesses if you choose to, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands these rights they'll be waiving by pleading guilty to these charges?
Yes, I am.
Mr. Thomas, has anyone forced or under promised you anything to get you to enter a guilty plea?
No, ma'am.
And is it your decision to waive these rights we just talked about and enter a guilty plea because you're in fact guilty?
No, ma'am.
You have to say yes to that one.
Mr. Thomas, she needs to repeat that and you need to listen to it.
What?
Say it one more time, ma'am.
And is it your decision to waive these rights we just talked about and enter a guilty plea because you are in fact guilty?
Okay. Yes, ma'am.
As to indictment number 26 SC 001319, how do you plead to count 1 reduced to disorderly conduct
Guilty.
and count 4 willful obstruction of law enforcement officer?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
No, ma'am.
Listen again.
Mr. Thomas, I don't know what you're looking at, but please pay attention to Ms. Foster when she's talking.
Are you high?
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand what you're doing here today, Mr. Thomas?
Yes, I do, but I really don't understand the question.
If you could just break it in. Yeah, go ahead, Mr. Pitts.
Do you have full knowledge of what's
Yes,
going on
I
here
do.
today and
Yes,
what the charges
yes.
are and what you're doing?
Yes.
And you're doing this willingly and voluntarily?
Yes.
Thank you.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there's some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal, which is outlined in OCGA 5-6-35.
Yes, ma'am.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, if this case were to proceed to trial, the state would show that on... Oh, well, Your Honor, the state can give a factual basis unless the defense stipulates.
We'll stipulate, Your Honor.
Just give me the basics of that the victim has a position and the reason for the reduction.
Yeah, so the victim did want to join on Zoom, but I guess he wasn't able to be here. The victim is okay with the charges as reduced. They are from Louisiana, I believe, and he basically called the police to try to get the police to de-escalate the situation. But when the police arrived, they did let him know that, that the defendant did have a knife in his hand, and at that point they were going to arrest him. He believed that this is the best outcome for Mr. Thomas, especially with the mental health evaluation and treatment being included. Nothing further from the state.
All right. And is Mr. Thomas eligible for first offender treatment? Has he been advised of that possibility, Mr. Pitts?
We discussed first offender before the state agreed to reduce this to a misdemeanor. We were planning to enter it as a first offender for a felony, but as it's now a misdemeanor, my advice is hold on to that. He's still quite young.
All right. Okay. And so, Mr. Pitts, anything else?
Yes, Judge. The victim in this case, Mr. Levy, is Mr. Thomas's cousin. As the state rightly stated, Mr. Levy has told me on the phone that he is from Louisiana. There, they can reach out to police merely to have a situation de-escalated, but when police arrived here, they essentially told him that in Fulton County, if you call the police, somebody's going to jail, which was quite shocking to him. He is comfortable, and they both tell me that they're in a good place with each other as cousins. Mr. Thomas resides in Memphis, Tennessee. Mr. Levy resides in Dallas, Texas, so there's no issues between them getting into further trouble like this. So we will be asking the court to permit Mr. Thomas to phone report for misdemeanor probation as he lives in Memphis, and that's where he's visiting us via Zoom from today.
And no objection from the state.
Thomas is in another
All
world.
Right. And so, Mr. Thomas, to confirm, this is your decision. It's a free and voluntary decision on your part?
Yes, sir.
And Mr. Pitts, you're satisfied your client is competent and that it's entered knowingly and voluntarily?
Yes, Your Honor.
All right. Well, I agree. I'll make those same findings, that there is a sufficient factual basis and that this plea is entered voluntarily and intelligently. And I'll sentence you, Mr. Thomas, as recommended by the parties, which on count 1 reduced to disorderly is 12 months. I also see you served over a month already in pretrial confinement, so it would be 12 months to serve 1 month with the balance on probation. Count 4 is the same sentence to run concurrent. Your special conditions are as mentioned by the state: no weapons, no drugs or alcohol without a valid prescription, 40 hours of community service. You complete a mental health evaluation and follow any recommended treatment, no violent contact. You complete the family violence intervention program. Was that here? I mean, are they living together?
No, Judge. One lives in Memphis, one lives in Dallas.
Yeah, so we can
It's a pretty onerous program.
we can scratch that.
Okay, we'll leave that off. No, we've got the community service, we've got the mental health treatment, and then, sir, your probation can also be phone reporting. And so, do you have any questions about anything we've covered here today?
No, sir.
All right. Well, we've got your contact information, so misdemeanor probation will be reaching out to you. You need to return that call, and you'll follow up with them from here on out. Okay?
Yes, yes, sir.
All right. Unless there's anything else for the record, Mr. Pitts?
Last thing real quickly, I have provided his contact information, phone number, address, and email address, as well as the cousin's phone number for an emergency contact to Ms. Fortis this morning. And I will provide Mr. Thomas with a copy of the disposition as soon as we have it.
All right. Okay. Well, then that concludes this matter. And Mr. Thomas, best of luck to you. And we'll be off the record. You can log off, sir.
Thank you, Judge.
I don't know what. I've never seen a more
All right.
disinterested.
And then we had Mr. Bray.
Disinterested
if we could bring out Mr. Bray.
Oh, man. Maybe ADHD. He was definitely looking at something.
We have Mr. Bray and Mr. Ray. Is Mr. Ray still a bond motion?
Ms. Ray.
Ms. Ray, excuse me. That's still a bond motion, right?
That's a plea.
It's going to be a plea.
It's a plea now. Okay.
Even better.
You're welcome to stick around after this is done. If you want to watch this, it seems quite invigorating.
Tree law, right, Judge? Tree law.
Yes, tree law.
Just join one of the tables.
I was actually thinking if the state would consent, we need to do more of those in our arena.
More bench trials?
Yes.
Richard Marks, we did 2 of them with him. It was remarkable.
Katie Bud, thank you very much.
Right. I need your autograph right there before we get started, Mr. Bray.
He also agreed to an 11-person verdict once because it was a hung jury. What's that? And he won it. Yeah, he won that one.
Remember, I was on vacation, then I got the text, and I was like, that's not. That's,
Why did you agree to that? Oh, he must
Oh,
just,
you won.
he had that feeling. He knew. All right, we ready with Mr. Bray? Then we're on the record now. 25 SC 006-402, State versus Ricardo Bray, present in court with his counsel, Mr. Pitts. State here through Ms. Foster. And Mr. Bray had previously been on a trial calendar, but the parties had mentioned accountability court being explored. Is that still this outcome here? We've come up with
It is
something
not,
else.
Judge. Accountability Court has been their usual helpful selves. They will not continue evaluating him because they have discovered that he apparently, in their evaluation of his GCIC, his Georgia criminal information, has a warrant from a municipality for a misdemeanor in the state of Arkansas. Not an extradition, not a hold, just a warrant for a misdemeanor.
And that's
So they won't
disqualifying.
continue their evaluation.
How do you feel about that, sir?
So,
All right. Well, Mr. Bray, at this point, the state's going to swear you in. They have to advise you of all the rights you would waive by entering a plea. All right. So listen very carefully. Ms. Foster.
Mr. Pitts, 1 second. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand. Could you please state and spell your true, correct legal name?
My name is Ricardo Bray, Recardo, last name Bray.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Can you repeat that, please? No.
How old are you and how far have you gone to school?
I am born in 75, so I'm what?
51.
actually, you're 51. You had a birthday this
51,
week.
yeah.
And how
Hey,
far have you
call
gone to
it.
school?
Did I call it?
I think I went to the 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses on this indictment? Aggravated assault?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you can have a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
No.
Are you satisfied with your attorney's services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes, I am.
And have you reviewed the indictment?
I have reviewed it. We waive reading. I don't believe there are any defects.
Just get to the tree law
Bray, have you
already.
been arrested on these charges?
Have I who?
Were you arrested on these charges?
Yes, ma'am.
You under the state is unaware of any outstanding warrants related to these charges. Mr. Bray, do you understand that you're entering a guilty plea to the following offenses? Aggravated assault, which carries a minimum of 1 year and a maximum of 20 years.
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to?
Yes, ma'am.
Do you understand this negotiated plea of guilty, which means the state will recommend to the court a sentence of 7 years to serve 1, time served on that 1 year. The special conditions will include no weapons or replicas of weapons, an anger management course, continued mental health treatment, no drugs unless valid prescription, no further violations of the law, and no further contact with the victim in this case?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and the court can sentence you to the maximum on each charge? It can run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand the general conditions of probation?
Yes, ma'am.
Do you understand if you violate any laws or conditions, the court could bring you back for a revocation, which means you could spend additional time in custody?
Yes, ma'am.
Do you understand this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you are charged with a crime in the future, this plea may be used to enhance sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you are currently on probation and parole, your probation and parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand then that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you could not use, receive, possess, transfer, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defense, by entering a plea of guilty?
Yes, ma'am.
You understand that by pleading guilty, you're giving up the following rights. I'm going to say them one at a time to make sure you understand. The right to trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses against you and to question them, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, which means the state must prove you are guilty of each charge beyond a reasonable doubt, the right to testify on your own behalf or remain silent, and the jury will be told they cannot use your choice against you, the right to present other evidence of your own and call your own witnesses if you choose to, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands these rights they'll be waiving by pleading guilty to these charges?
Yes, I am.
Mr. Bray, has anyone forced you or promised you anything to get you to enter a guilty plea?
No, ma'am.
And is it your decision to waive these rights we just talked about and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
As to indictment number 25ST0064002, how do you plead?
Guilty.
Hang on.
Is this guilty?
Well, he pleads guilty. I'm struggling. This lady, is it her accent? She drops some letters. She drops S's. She drops P's. Sometimes, but not all the time. I don't think it's a that. So I'm not. I hesitated to bring it up. I don't think it's a speech impediment because she can use all those sounds. Other times, like she uses the S's and the P's and everything, but then she just slurs her words together. And look at the defendant's face. He's standing there next to her, and look at the confused look on his face. He's like, "I'm not sure I understand you. I understand English, but she's going just too fast."
A family member of the defendant.
Family member.
He did state that he was suffering with pain and anxiety, and that he did want to see the defendant serve jail time. The defendant was in custody for over 200 days, and we believe that jail time is sufficient. And he's just asking to put this behind him as well. Nothing further from the state.
Any probation issues, Mr. Kuzu? Mr. Pitts?
Yes, Judge. As the state stated, the victim in this case was a family member, a cousin, and Bray himself was distraught over the passing of his mother, and there was something said that sent him over the edge. When I first met him, he very tearfully stated to me that he didn't mean for this to happen. He's been of a position that he was prepared to resolve this all along. As we've already let the court know, we attempted to present this to the Behavioral Health Treatment Court for resolution. Mr. Bray does take medication at the jail. I've spoken with him. He is familiar with Grady at 10 Park Place and knows that that's where he can go to continue receiving his medications. He and I have spoken at length about how important it is for him to continue the medication because it keeps him focused and in a good place. And when he's off it, it is not a pretty picture. He anticipates that at least initially he'll return to the family residence here in the Atlanta area on Fairburn Road. He notes that he has been informed that his cousin, the victim in this case, has moved to Noonan, Georgia. He also is contemplating a move himself to the Pine Mountain, Georgia area, where his father as well as his son reside. In addition to that son, Mr. Bray has two other adult children. He lets me know that he is an over-the-road truck driver. He's looking forward to getting back to work doing that. So he would like the court to understand and permit him to undertake that employment. He does hold a CDL, he tells me. And with that, Judge, we would ask the court to receive the plea as negotiated.
All right, Mr. Bray, so I just need to confirm you understand the nature of this charge? What this charge is about, aggravated assault?
Just have to say yes or no.
Oh, yes.
And I just also need to make sure this is your decision and it's a free and intelligent decision on your part.
Yes.
Okay. And Mr. Pitts, you're satisfied your client is competent?
Yes, Your Honor.
Okay, I will find that there is a sufficient factual basis and that the plea is entered voluntarily and intelligently. And I'll sentence you, Mr. Bray. Again, I just want to ask for the record, is he eligible for first offender?
He is not, Your Honor.
Okay. Then I'll sentence you, Mr. Bray, as recommended, which on aggravated assault is 7 years to serve 6 months with a balance on probation. You get full credit for that 217 days that you've already done. The special conditions: no weapons, no drugs or alcohol without a valid prescription. You take an anger management course. Mental health, you keep following any treatment you've been prescribed. And your cousin apparently doesn't want any contact with you, so you shouldn't be in any way reaching out to him in any form while under this probated sentence. I'll put in a special condition here as well that you can leave the state for purposes of work, just in case that's an issue with probation. And for any technical violations like failing to report, those will be handled by your probation officer with a sentencing cap of PDC or RSAT under the sentencing options system. Do you have any questions, Mr. Brave, on anything we've covered here today?
No, sir. Oh, yeah.
All right. Well, I wish you the best of luck. That'll resolve your case with us here today, okay?
Thank you.
All right. Mr. Kuzer from probation will be meeting with you before you leave.
Yes, sir.
We're off the record. Take care.
Thank you.
Thank you, Judge. That concludes my business. May I be excused once I
If you
watch
insist.
Mr. Simonov's bit?
Can we
All
start the
right.
tree stuff?
Thank you.
I want to hear tree law.
Okay, then I believe we have Miss Ray coming out next.
Okay, we're gonna go back to the tree.
And then from there, I think we'll pause and y'all have a bunch of probation cases to talk through and that sort of thing.
Yeah, we're talking.
Yeah, so that we'd probably take up at a lunch break.
That's fine.
Oh, they didn't transport everybody? No. Okay.
We'll talk about all of them and
Yeah.
see how many orders we can send you.
All
Let
right.
me jump back to this one for a second. Hang on. Whiplash.
I've been
Okay.
writing many years. I'm 40 years old. I also run a group. There, a group of writers. There's about 2,000 of us. I'm the founder of them. I am the guy who always tells other writers to be careful, write in their own lane, try not to speed.
He has a lot of shoes.
And I respect officers. There's a lot of my writers that do fly. They pull away from officers. They run from officers. So on. But on this day, I was behind flow of traffic. And such, I was behind this a silver Kia. It was a Kia, a Stinger. Me and that
Okay,
Stinger.
hang on. I'm drawing it. Okay, so the patrol car is ahead of you.
Yes, the
And you're behind, and then there's
I
a
need my Hot
Kia
Wheels cars.
in between you and the patrol car.
So okay, so me and
Do I
the
have
Kia-
it right?
Yes, correct.
Are you in? Let me ask you something. Are you in a construction zone?
696 is well, the on the yes sorry, eastbound is. I don't even know because they turned the eastbound into westbound. So none of it is a construction zone except for the other side of the barrier.
Okay.
But mind you, regardless, I'm sorry. Yes, that the whole freeway is considered a construction zone, but I
Okay,
wasn't.
so all right, let's get back to what was happening.
Yes,
on that
exactly.
day.
So
You have the patrol car and the Kia and the defendant.
yes, so he was on the far left lane, going the speed he said he was going. I was in the far right lane behind a gray Kia. I remember the car. There was no vehicles in the middle lane. So when me and the Kia was coming up, mind you, my bike is loud. So I don't know if the sound of my bike triggers him or he's has some type of issue with other bikers flying and not stopping for him.
Is that the Kia driver or he being Sergeant James?
Sergeant James.
Okay.
Because I think bikes trigger him. And I'm gonna tell you this why. Because like I said, when I was behind the Kia, me, the Kia, and Sergeant James, that's on the left side. I don't know what speed limit we were going because on a bike we don't really look at our speed limit unless we're not in front of another vehicle. But because I was behind flow of traffic, I wasn't really paying attention to my speed limit anyway. Because and especially me knowing that the Sergeant James is on the far left side. So anyway, what happened was
PNW.
I
this
felt
link
like
is
I
for
was
you.
going too slow, so I was about to go around the Kia. I jumped in the middle lane, but then I realized I was like, Sergeant James is slowing down. So I slowed down and jumped back behind the Kia intentionally so I can avoid any problems with Sergeant James. Sergeant James, so
if I'm looking down, I'm taking notes on what you're saying, but I'm listening.
What I'm gonna say is me and the Kia did not pass Sergeant.
Okay, so you felt like you were going too slow.
This guy tries to sell you
So
a
you went in
cellular
the middle
phone.
lane and then
At
you
Sam's
saw
Club, too.
Sergeant James and then you moved back behind the Kia.
Because I noticed Sergeant James' vehicle started slowing down. So my intuition told me, you know what, just get back behind the vehicle and just pace again. What happened was, technically Sergeant James is in line because we did pass him, but that's because Sergeant James slowed down intentionally to get behind me in the Kia. But instead of him pulling over the Kia, which was doing the exact same speed that I was doing, he pulled me over.
Okay.
And then, like I said, I didn't even know I didn't even know he was going to write a 95 miles per hour ticket until I seen the ticket.
Well, how fast do you think you were going? Because you said
maybe 100.
Said that or testified that.
Granted, I didn't know that 696 was 60 miles per hour, but we was not doing 95 because me, the Kia, and any other vehicle that was on the freeway clearly seeing Sergeant James in the far left side and hit on his blue vehicle. It wasn't unmarked or anything.
There's no way we would have sped past him.
It was clear as day.
Plus, a Kia can't even do 90.
I can guarantee you we wasn't doing 60, but we was doing nowhere near 95, let alone, I don't even think we was doing over 75, but we definitely wasn't doing 60.
Do you think you were going between 60 and 75?
I would say 60 and I would say 65 and 70, but 95 is outrageous. 95 is outrageous, even for a sergeant's standard. That's ridiculous. 95 is ridiculous. That's why I can't.
So do you think the radar is wrong?
See, he made a statement that it's been I feel like something's not right with this situation because I know I'm not wrong. I've been a driver for many years, and normally, if you look at my track record, if I ever caught a ticket or anything, normally I won't even have a hearing. I would just pay the ticket and I would just leave it alone.
So you have a history of speeding?
I've never asked for a hearing during a ticket at all. Normally, I would just move on and continue with my life. So this is all new to me.
Okay.
95 is outrageous.
Okay.
We think so as well.
Sergeant James, do you recall in this incident having seen is it silver Kia?
I do, ma'am.
Okay. All right. Thank you. So what do you recall about that? Do you have any, can you answer or respond to his testimony for the court, please?
Yes, ma'am. Mr. Hicks and I are pretty much in agreement on his statement. He was behind that vehicle, and as I initially testified, he merged around that vehicle and then began accelerating past that vehicle, closing on my vehicle. At that time is when I received the speed measurement.
Okay. Is there a reason why the sergeant didn't take action with the Kia?
Because Mr. Hicks passed the Kia, making him the fastest traffic on the roadway.
Okay. Did you see him pass the Kia and then slow down and go behind the Kia?
I saw him pass the Kia. I don't remember his positioning afterwards.
Okay.
So I never clearly passed.
Okay, 1 second.
Okay, sorry.
Okay.
Go ahead. I'm sorry.
Okay, anything further, Sergeant James?
No, ma'am.
Okay. Mr. Hicks, now I'd like to hear from you.
I never completely passed the Kia. When I got over to merged over to the middle lane, I sped up just a little bit. I didn't pass the Kia, and then I realized that Sergeant James started slowing down. He didn't hit the brakes, but it was noticeable that he was slowing down. So I slowed down and jumped right back behind the Kia because I didn't want that interaction. I had nothing.
What interaction?
I had license, insurance, and everything. I just didn't want the interaction, so I jumped back behind the Kia. But to say that I passed the Kia and to go 95 is just outrageous. Like I said, I don't know if motorcycles are a trigger for him. I don't know what he was going through that day. But there was no intention to break any laws that day, especially because I'm a huge advocate for other bikers.
Okay.
Especially for pulling over for officers and everything. That's not me.
Sergeant, do you have a trigger with motorcycles? Are you yeah, Sergeant, do you have a thing where you are offended by them or?
No, ma'am, I have a psycho endorsement myself.
Okay.
I'm in his group.
All right.
We ride on Saturdays. Sorry, this is funny. And I have a Kia.
I'm going to find you responsible for the ticket, but I'm going to have somewhat sympathy for the court. I'm going to find you responsible for 15 limited access 16 to 20. And that's $200. How long do you need to pay?
May I ask all? Oh my God.
Okay, let me just say something. I'm just going to tell you something. Based upon what I heard, I would, if I was being very strict and had no heartstrings that you could pull on, I would find you responsible for the ticket as written. I'm exercising very little discretion that I have, and I'm removing the construction zone endorsement, and I'm lowering the points because, as I said, you are looking at over 355, 31 to 35. Like, my construction zone on my scale only goes to 326 to 30, which means this is more. Okay, so I'm now changing it from $355 in a construction zone and 5 points to limited access 16 to 20 over, which is $200 and 3 points, which you should get it.
I get it. It just hurts me regardless because I'm in trucking school also. So the ticket just this just hurts me bad.
I know. That's why, I was trying to put you in a different line, but you wanted to have the hearing. And so I'm trying. Listen, what I'm trying to do. I tried to give you what you want and had an informal hearing. If I was strict letter by the law, you would walk out of here with 5 points construction zone, more than 5 points. I don't even know what it is because I don't do the points as Secretary of State. I feel that your impassioned presentation and the communities in which you ride maybe got just the day got away from you. Okay. So I'd like to show you some courtesy, and I'm trying to show respect for law enforcement who was on the road and saw that. So I kind of just balanced
law enforcement. I want to say that I do respect law enforcement. I just can't agree to 95 miles per hour.
I know you didn't, and that's why I gave you a ruling. You didn't agree. We had a hearing, and I've given you the ruling. So how long do you need to pay?
I can pay immediately.
Okay. Let me look. Limited access. How many? There's no driver school for that, is there, Sergeant? Is there something?
For what, ma'am?
If I say limited access 16 to 20, that's $200 and 3 points. If I did limited access 11 to 15, is there some kind of program with the state that he would qualify for?
That'd be based off of Mr. Hicks's previous driving record.
Oh, I don't know it. I don't know.
Well, we could look
I
at
didn't
that.
look at it.
Let's
Okay,
take a peek.
so I don't have it either. So
He has some prior speeding.
now here's one thing, sir. You can file an appeal if you're unhappy with the ruling and have a new hearing before the trial court. As the sergeant can, he can also file for a hearing. Okay? So the court will give you 7 days to pay. All right?
Okay.
All right. And if you're dissatisfied and you want to have a new hearing, either one of you, you may file an appeal and have a hearing with the trial court.
Thank you.
Thank you. Good luck to both. Oh, no. I have another case here for Sergeant James. Who do we have here? McNutt. Okay, calling the case number of SP 4655567. This is the state of Michigan versus Jennifer McNutt. Your appearance, please, ma'am.
Jennifer McNutt.
I'm sorry, Sergeant, I overlooked you. Your appearance, please.
That's okay, ma'am. Sergeant James, Michigan State Police, Metro North Post.
Okay, sorry for the late delay in calling your case, ma'am. Were you present for the previous cases?
Yes, I was.
Do you need anything repeated?
No, I do not.
Okay, what's your choice?
I do want to take responsibility with explanation.
What would you like the sergeant to hear about you?
Our interactions was very respectful and positive. What was happening that day, I was headed into work and we had a kiddo sitting at the office that needed to be monitored. So I just got distracted.
Are you a teacher?
I'm not a teacher. I'm a social worker. I work for a private agency in child welfare.
That's very admirable work. You have a hard job.
Thank you. I appreciate it. So I just got distracted, and with the construction zone and the changing of the speed limits, it was just something I didn't pay attention to in that moment. I did not maintain that higher speed rate. I did review an article from the National Highway Traffic Safety Administration in regards to speeding, and I've implemented utilizing cruise control to better suit my driving needs.
Okay. Sergeant, having heard all that?
Yes, ma'am. I'd like to.
She really did her homework.
She certainly did.
Forward it to me so I know what it says too.
I would like to offer a 0-point reduction to limited access speed 1 to 5 over, ma'am.
Okay, he's reducing your ticket to 1 to 5. No construction zone, right?
That's correct, ma'am. No construction.
Okay, so he's removing, like, it's a heightened fines and costs in a construction zone. So by removing that, and he's giving you a ticket for limited access at speeding 1 to 5 over, any objection?
No.
Okay, the court finds you do you admit responsibility to limited access 1 to 5 over?
Yes, I do.
That's $130. How long do you need to pay?
I could pay that today.
Okay, you can pay online, you can come in person, you can mail us some money order, a check.
Would it be ready right now, or do I have to give some time for it to update to reflect the change?
Lisa, can they go on right now and pay, or do we have to update?
Let's see if we're back to the tree
You can
thing.
go right now and pay. It's $130 on.
Let's see if we're ready for trees.
Let's dig into all that.
That motorcycle one was funny. I think he was lying, though. Not the officer, the rider. This courtroom's quite bright. This camera is like overexposed a little bit. Looks like they're getting set for the tree argument.
Jeez. All right. All right. Have a good weekend. See ya.
See ya.
I don't remember who had a witness on Zoom. Who was going first?
That's me.
Are they still in the meeting? What's their name again?
Mr. Bernhard, Gerald Bernhard.
You can tell them to get up in there.
Didn't drop off.
Yeah.
Got it.
We also had,
Signing on now.
we also had Melanie Nealis
I don't see
in the
her.
afternoon.
Oh, and that.
In the afternoon. I need to call her and she'll get on.
You ready? Okay. We are back on the record for our bench trial, and all parties and counsel are present. Thank you for your patience. I think the plan of attack here, we'll see how far we get, but I'd say we get at least through one witness, direct and cross, before we break for lunch. Brief recess, and then we'll come back and resume.
We're a tree trial.
Anything to announce or take up on behalf of the petitioner?
We tried for a while out there, but haven't gotten anywhere.
All right. And then in which case, petitioner can call their first witness.
Your Honor, we'd like to call Gerald Bernhard, and he's on Zoom. All right, I think Mr. Bernhard's on mute.
Nice job.
No, he's just whispering.
There, I guess. There they are. Can you? All right, Mr. Bernhard, if you could, I think on your end, there might be a button on your screen to unmute yourself.
Okay.
There you are. Can you hear us all right, sir?
Yes, sir.
All right, we're gonna. We have the deputy here who's gonna swear you in.
Okay.
Raise your right hand for me. Raise your right hand.
That's right.
Do you swear affirm to the testimony the matter of this case you should give is the truth and nothing but the truth to help you?
Yes.
All right.
Okay.
You can lower your hand. Would you please state and spell your name for the court?
Gerald Bernard, GeraldBernhard.
All right, good morning, Mr. Bernard. Can you hear me okay?
Yes.
All right. We've previously met or talked over the phone. My name's David Klein. I represent the petitioner, Miss Martin, in this case, and just have a couple questions for you this morning.
All right.
How long have you been a licensed land surveyor in Georgia?
I've been licensed since 1996, and I've been surveying since 1978.
Do you hold any other certifications other than your license?
Like an arborist or something?
I also am licensed to do hydrology.
Can you briefly describe your education and training in land surveying?
I look at trees.
Yes, I took courses in land surveying, and I also have been experienced for 48 years.
And approximately how many boundary surveys have you taken during the course of your career?
I'd say 10 to 15,000.
Have you been previously qualified as an expert witness in Georgia courts?
Yes, I have.
All right. And Mr. Bernard, how are you being compensated for today's testimony?
I'm being compensated for drive time, which I'm not driving, but also $150 an hour for testimony.
And is the opinion that you're going to offer today in any way contingent on the outcome of this case or how you're being paid?
No.
All right.
I get
Your Honor, I
paid no
move
matter
to
what.
qualify Mr. Bernard as an expert in land surveying.
Any objection?
No objection.
You can proceed.
Mr. Bernard, you were retained by Ms. Martin to survey the property at 920 Wendover Drive, Northeast in Atlanta. Is that correct?
Yes.
As part of your work, did you review the deed for the property at 920 Wendover Ave?
Yes, I did.
Does the legal description in Ms. Martin's deed match the boundary lines shown on your survey that we'll get to in just a second?
Yes, they do.
When did you first perform a survey of this property?
I believe it was April of 2024.
Would it have been in February of 2024?
It could have been.
Sometime in 2024?
Yes.
What's a
that is
couple
correct.
months between friends?
What is the standard methodology, just generally, that you use to establish a boundary line when it comes to residential surveys? What are you looking for? Uh-oh. You might have frozen. Oh.
I'm sorry.
And he gone. Maybe you should get compensated for a little drive time and get to a place with a better signal, sir.
Can you hear me?
Okay, I'm sorry. Yeah.
Okay. Can you just take me through your methodology in performing a boundary line survey? What are you looking for?
We're looking for the property corners, where the street's at, any fence lines that, might be close to where they're at. And once we find at least 2 pins and the road located correctly, then I calculate where the pin should be that I didn't find. And then I go back out, which I went out with the crew. I go back out and stake out where they're at, and then I found an open top pin where I'd calculate where one went, and it hit perfect. And so we staked out where the other ones were at, and there were no pins there, and we set them.
All right. So the first time you went out to the property, you couldn't locate a pin. Is that right?
Yes, that is correct.
Do you remember which pin that was?
I believe it was on the east side of the property in the rear, the open top pin.
Was that located behind a fence?
Yes.
Okay. And so eventually you had to come out and do another survey or updated survey of the property. Okay.
That is correct.
All right. Despite being unable to access that pin during the original 2024 survey, were you able to still determine what the boundary line was between the two properties?
Yes, sir.
How were you able to do that without having access to that pin in the eastern side of the property?
I calculated up from the road and the pin I found and calculated where it went. And before, I would set any pins, I stake them out to where I've calculated to see if they're there. And I found that one particular.
And I think you testified it's common in your profession to establish a boundary line even when a pin is inaccessible or missing?
That's correct.
All right. Based on the 2024 survey, so the first time that you went out to the property, what did you determine regarding the fence? Was it over the property line, on the property line, behind the property line?
It was over the property line.
Okay. And so it encroached on Miss Martin's property, is that correct?
Your Honor,
That is correct.
As witness, I object.
All right. In the interest of time, I'll overrule the objection.
Were there any other items besides the fence that you observed over the property line?
No.
Okay. In your professional opinion, was the 2024 version of the survey reliable and complete enough to establish the boundary line even without access to that one pin?
That is correct.
Okay. I'm going to pull this up on the screen.
Okay.
Oh, we get to see. This is going to be great. Show us the trees.
I need to be enabled. Sorry.
And Judge, that's your guys' job.
Nice athletically. Then geographically. Then by square footage.
Okay. Can you see this document, Mr. Barnard?
Yes.
Okay. This is exhibit P1. It's actually attached to a letter that I sent, but I'm just going to focus on the survey. Is this the original version of the survey from 2024?
Yes, it is.
All right. And then I'm going to pull up what's exhibit P3. Is this the updated version of that survey?
Yes, it is.
All right. And is there any difference between these two surveys?
They could be a slight difference. In our profession, that anything that's within 800ths or less, we hold it and put down what the deed is.
And
so it could be less than a tenth off, but not anything more.
That'd be a tenth of an inch?
Tenth of a foot.
Okay.
So base
and that's
a
professional
little more than an
standards
inch.
for land surveyors.
Okay.
Tenth of a foot. So 1.2 inches.
And between the two surveys, the fence was still encroaching. Is that correct?
That is correct.
And were there other encroachments as well that were still encroaching?
Not that I can see, no.
Based on your two surveys, how far over the property line was the fence? Can you give me some kind of estimate on that?
It's approximately a foot to a foot and a half.
Okay.
In some areas, as you see, it bends out and then comes back in.
And approximately how long was the fence from top to bottom?
I would say it was about 110 feet.
It's a big fence.
Mr. Bernard, as part of your company's work on this property, was the boundary line physically staked or marked?
It was marked.
Okay. Let me pull up Another exhibit here for you.
I need to see. Oh, there we
Okay.
go.
Can you see this exhibit, which is marked as P5?
Yes.
All right.
Is that a concrete fence?
Is this one of your stakes here?
I don't see it.
Let me zoom in a little bit more.
It's right there in the
Okay.
middle. The thing casting the shadow in the middle of the screen. Right there.
Yes.
Okay, that would be one of the stakes that your company placed?
Yeah. Yes.
All right.
On the property line.
And those stakes would have been placed at the initial survey date in 2024, is that correct?
That's correct.
Would you say that the boundary line here was clearly and accurately marked?
Yes.
Was this stake visible to someone standing in the backyard of either property?
Yes.
Mr. Bernard, in your professional opinion, is there any ambiguity about where the boundary line falls between these two properties?
No, sir.
And both your 2024 survey and then the 2025 survey with the updated pin position, they reached the same conclusion about that boundary line. Is that correct?
That's correct.
Mr.
About 2
Bernard,
feet, right?
in your professional opinion, before a homeowner builds a fence on or near a property line, should they obtain a survey?
Yes.
Why is
They
that?
should have their property line staked to make sure the fence is on their property.
And before placing the stake on during your 2024 field site visit, you didn't see any other stakes or markings about the boundary line, correct?
No.
What about before doing grading work near a property line? Should a homeowner get a survey?
Yes.
Yes.
And what about for installing artificial turf? Is it your professional opinion that they should get a survey?
Yes.
All right. Thank you, Your Honor. No further questions.
It's a little self-serving.
Let me ask one before we get to cross. I just, sir, if you could look at P3 again, I want to make sure I am understanding this diagram right.
I'm just going to pull this up, Your Honor.
Okay. And if you could perhaps
Folly.
zoom in on the
I believe
lot
you're right.
itself.
The fence
All
belonged
right,
to the
so-
house.
All right, so just
the
I want to
right.
make sure. So like the dotted line, you know what? I forget my shapes, but maybe a rhomboid of some kind. That would be the house.
That would be the dotted line is the setback lines.
Or it says BSL.
Yes. Like
So what is that?
back set line, side set line. It's building set line.
Okay. And so that's the structure.
Yes.
Okay.
Well,
and
it's
then
not the structure. It's where you can put the structure in.
I understand. Okay, thank you. And then the next dotted line closest to that,
The dot.
if I go
The
from
dash and
the
dots.
to the right of the page, is that the fence line as you surveyed it?
Yes.
And then the solid line is the actual boundary line that you surveyed. Is that accurate?
That is correct.
All right. And so the encroachment that you were focused on where you couldn't locate the pin originally, that's on the right side of this diagram?
Yes.
And that fence then travels all the way around and actually goes into the other neighbor's yard on the left side of the house?
That is correct.
All right.
Okay, so it belongs to the middle. one.
And cross, or if you want to follow up on any of those points.
Thank you, Your Honor. I'm going to put up another survey. It's the same one, but it's
Easier to read, please.
highlighted.
How many hours of lawyer fees are involved in disputing this property, and what's the value of the property? Hello, sir. Welcome.
All right, sir.
Now, Mr. Bernard, we've never met before, right?
No, sir.
My name is Alan Miller, and I represent the Thomases, the defendants here.
The pink
I just
people?
had a couple questions about your survey. As the judge just pointed out, this line at the bottom of what was the fence is showing a little line that goes perpendicular to the fence. Do you see that?
Yes.
Do you know who owned that fence? Sir, did you hear me?
I'm looking at it right now. It looks like it would be the person that we did the survey for.
Okay. And that fence came out and connected with the fence that was determined to be the Thomas's fence, right?
Thomas's have the property to the right.
Which one is the Thomas's fence?
So
I know
The fence
the
Thomas's
Martin's
over
to
here.
the left. Is that correct? And then the Thomas is one we surveyed for?
No, you surveyed for the Martins,
Okay.
and
Okay.
their house is in the pink
Yes.
lined area. And then it shows at the bottom on the right side, it shows a connecting fence
Yes.
that you've identified as Miss Martin's fence.
That
And
is
then it
correct.
connected to the fence that's indicated on your diagram as the Thomas's fence, right? Do you see that?
I see it as being the Martin's fence going down and over to the connecting together. I don't see it connecting to any other fence line.
Okay, well, if you follow that little perpendicular line towards the middle,
Yes. Yes.
connects with the what's indicated as a fence there, and it's your
Yes.
understanding that that was the Martin's fence?
Yes.
Okay, and that goes around, just like the judge said, it goes around to the other side, and it actually shows a fence over the boundary line on the other side of Miss Martin's property, correct?
It shows a encroachment on the western side of the property.
Okay, so do you have
It's
an
the left
understanding
side
as to where the Thomases are in relation to
No.
this survey?
No, I don't.
Okay. Well, getting back to this fence, it shows an encroachment by Miss Martin's fence on the property to the left of Miss Martin, right?
So Ms.
Yes.
Martin's pink in the middle. That's her house.
And you actually retained on February 21st, according to an affidavit that you gave in this case on November 17th of 2025. Do you remember giving that affidavit?
Yes, I do.
Okay. In the second paragraph, or not second paragraph, but the second paragraph on the second page, it states that on or around February 21st, 2024, I visited the Martin property to perform a survey, correct?
Correct.
So you were actually out there on February 21st of 2024. Do you know in the initial conversation why it was that Miss Martin wanted you to survey the property in the first place?
No, I didn't take the survey order. I just performed the surveys.
So did you talk to Miss Martin about being retained to do the survey then in
No.
February of 2024?
No. That
Okay,
goes
so-
through the office.
Okay. So you don't know why she wanted you to go out and do a survey then?
No, sir.
Okay. And your first visit in February 21st, 2024, did you meet with an attorney there by the name of King Buttermore?
No.
You don't remember meeting with him?
No, I did not meet. I don't actually perform the actual surveys. The survey crew does. I go out and look at the property. I just visit it to see when they're doing it, how to reproduce it. And I tell them, then I leave. I just supervise, that's all.
So was it some guy by the name of Nate that actually did the survey?
That is correct.
So you didn't actually do the survey?
No, I supervise the surveys. Actual registered land surveyors hardly ever go out and survey property. They have field crews that go out and do the work.
That's beneath
And
us.
then we supervise the field
Great
crews.
Grinder.
work
OG.
And agree with it or not agree with it.
Well, in paragraph 9 of that same affidavit,
This
you
is a tree
indicate that at
case.
this visit to the Martin property,
Civil.
which was February 21st, 2024, you were unable to access a pen located in the northeastern corner part of the
That is-
Martin property, which is
that is
indicated as
correct.
CP on the original survey, right?
That's correct.
And that same pen on this page is indicated as OTP in that right corner. Is that correct?
That is correct. That is correct.
And you couldn't access that pen, so your survey, when you agree with me that the survey as of February 21st or 23rd of 2024 was incomplete?
Well, actually, what I did is I went back out there and had the survey crew stake it out to set the pin, but I found the pin then, and it was within the tolerance of acceptable survey standards.
Well, you were unable, is that true? You were unable to access the pen at this first initial visit? Is that true or not?
Find it. I didn't find it.
Okay. And then you were engaged again more than a year later, according to your affidavit, on about October 1st, I was engaged again by Ms. Martin to update the original survey. So
that's correct.
Would you agree with me that at least from February 21st of 2024 until October 1st of 2025, your survey was incomplete because you could not access that pen?
No, I wouldn't say it incomplete. I calculated in where it went. And with the business the way it is, sometimes it takes a while before we go back out and set pins.
Well, the survey was incomplete because you couldn't access the pen, right?
I couldn't find it.
Okay.
I could access the area it was at, but I didn't find it.
Wasn't it true that the pen was actually under a portion of the fence in that corner?
Not on the eastern side.
Well, I'm talking about the location of the OTP on this diagram on the
That is
survey.
correct. It wasn't under a fence or near. As you can see on the survey, you see the fence is well inside the property.
And was that October 1st, the first time that you were contacted about coming out and actually getting access to that pen?
Yes.
You weren't contacted in February of 25 that you had full access to the pen, that you could go out there and do it at that point in time?
Yes.
Now I'm talking about back in February of 25.
I know. I
Were you
didn't
contacted
find
then?
it. That's what I'm telling you is I didn't find it at that time. My survey crew didn't find it. I sent the survey crew back out at a later date, which was a year later or not quite a year later, and they found that pin. And
Didn't
it
they
was
have
in
to-
the area that I calculated off the first survey. Same area within tolerance.
Well, you'd agree with me
Welcome, J.M. McCarthy
that the
World.
survey was not complete until you actually were able to access that pen, wouldn't you?
No, I wouldn't say that. I said
Why
it was
not?
complete. I would say it was complete. The just pen that I'd calculated hadn't been set yet. But the survey was complete. It was good. There was no problem with it.
Now, when I asked you that question, I meant February of 25, not February of 24. And I think you misheard me there. Did anyone contact you in January, February of 25 and inform you that you had full access to that pen?
Not that I know of, no.
So no one contacted you until October of 25 and gave you access to that pen because it was underneath the fence, and the fence,
No, it
portions of the
wasn't
fence,
underneath the
wait a
fence.
second, wait till I finish the question. And you had to actually take some of the fence away, take it down in order to access that survey pen, which is located in that upper right corner, correct?
No. The fence, as you see where it's dotted line, is inside the property. The pen is outside the property. I mean, outside the fence line. It wasn't under the fence or anything.
So you're saying that the fence did not need to be removed or taken down in order to get to that survey pen?
Not that I know of, no.
All right. Now, The boundary line that you marked, that you say was marked in the front with that wooden post that's placed in P5, I believe it was, right?
I'm not sure what picture it was, but it was placed. Stakes were placed where the pins were set, and also stakes on the property line. And you could see from one pin down to the stake, and from that stake to the front pin.
Right. But the stake, the wooden post that you saw in P5
Yes.
was right next to the corner of the fence, right?
Yes.
And then you had the survey pin in the back, which was close to a chain link fence, right?
That is correct.
And those were the only two markers that marked that boundary line, correct?
I can't remember.
Well, there were
It's
no
been
flags.
well, I can't remember, but all
There were
I
no-
know is you could see from one pin to the stake, and from the stake to the front pin.
I understand that.
You
But those two
yeah,
markers, go ahead.
those markers, I put it there so you could see where the fence was.
My question is
There.
simply, those were the only two markers on that boundary line, correct?
Rear pin, that stake, and the front pin. That's correct.
There was nothing in the middle between the wooden stake and the survey pin in the back, was there?
No.
Thank you.
Can you redirect?
Just briefly.
Do you mind taking that down? Thank you. All right, Mr. Bernard, David Klein again. Just a couple follow-up questions. You understood that the 920 Wendover property was located to the west of the 930 Wendover property, is that correct?
That's correct.
Okay. And there were also some questions about whether the 2024 survey was complete. You previously testified that you can complete a survey even with a missing pin. Is that correct?
That is correct.
Leading as a witness again, Your Honor, we'd object.
All right. Again, it's going to depend on the context and the subject matter. And in this particular situation, I'll allow it. So it's overruled.
Did anything change between the two surveys?
Yes. We set the pins on that sideline and put a stake on the property line.
Okay. Did the property line change in any way that you're aware of?
No.
And the February 2024 survey and the October 2025 updated survey, those were both certified by you?
That is correct.
Okay. Do you remember anything about an access agreement?
No.
Okay. No further questions, Your Honor. Thank you.
Can you recross on those points?
So, Mr. Bernard, you have no knowledge of any access agreement that was entered into in July of 2025?
No.
And did anybody ever mention anything to you about an access agreement that was available as early as January, February of 25?
No.
Actually, Your Honor, facts, not evidence.
No further questions, Your Honor.
Overruled. All right. Can Mr. Klein be excused? Excuse me. Can Mr. Barner be excused?
Yes, he can be.
All right, sir. Thank you for your time. You can log off.
All right, sir. Thank you.
All right. Why don't we just at least get started with the next witness, Mr. Klein?
We'd like to call Bianca Martin to the stand.
Okay, this is one of the neighbors. This might be good. Is Bernard going to hang out and watch this with us? Oh, he gone. He gone.
Speaking to the mic of the state, spelling name support.
Brianka Martin,
BRIANCAMARTIN.
All right. Good morning, Miss Martin.
Morning.
What is your current address?
920 Georgia 30319.
When did you purchase that property?
April 21st, 2023.
What is the property next door to yours?
930 Wendover Drive Northeast.
And is that located what direction?
To my right, if you're facing the property, so I think that's east.
Who owns that property?
Brandy and Cedric Thomas.
After you moved in the property in 2023, can you tell me about any projects you had with the backyard of your property?
Yes, I was landscaping, just doing general beautification of the backyard.
Can you give me a couple more details about that? Like what beautification were you putting in? What
Bushes,
retaining
shrubs.
walls, things like that?
Yes, I plan to put in retaining walls, level out some of the property. Yes.
Okay. Obviously, this case is about a fence, so can you tell me when you first became concerned with your neighbor's fence?
Sure. During one of my landscaper's visits, the landscaper asked me about the fence to the right of my property and whether or not it was my my fence. And I said no. And I didn't think so because I had, again, just bought the home. But from my understanding of the conversation I had with him, the posts of the fence were facing the wrong way. And so he questioned me as to whether or not it was my fence or it belonged to my neighbor.
What did you do after that concern was raised?
I reached out to Survey Systems of Atlanta to perform a survey on my property.
And that survey was Mr. Bernard that we just heard from?
Yes, correct.
And when was that? What year, what month?
That was 2024,
Okay. Do you remember the month?
maybe February or April.
And once you had that survey
But not
completed, what
March.
did it show?
It showed that the fence to the right was on my property line, was on my side of the property.
Were there any other items besides the fence that were on your property?
Yes, artificial turf, a second fence, as well as some shrubbery.
All right, I'm going to pull up exhibits P4 and P5, which are already in evidence. And actually, I'll start with P5. All right, can you see that photograph okay?
Yes.
All right, can you explain what is being shown here? For instance, what side is your property? Where's your house located, et cetera?
My property is located to the left of the stake with the pink flag. The Thomas's property is to the right. And in the photo, I could see that the fence is to the left of the property line.
Do you know when this photograph was taken?
April of 2024.
Did you take this photograph?
No,
Who took this photograph?
the survey company.
And that stake that you can see there, who placed that?
Survey Systems of Atlanta.
Were there other stakes that were placed by the surveying company?
Yes.
Where at?
There was one that was placed between the one picture here and the street. And then they placed stakes to the left and the rear of my property as well.
All right. After you received the results of the survey, what did you do next?
I contacted an attorney.
Okay. Why did you feel like you had to contact an attorney?
The previous conversation I had with Mrs. Thomas, it was a text exchange. It was in reference to the tree, but she was citing regulations and using legal language. And at that point, I just felt uncomfortable having that conversation.
When did you have that text exchange with Miss Thomas?
February of 2024.
All right. So this is all happening around the same time period?
Yes, correct.
All right. And you retain my law firm to send a letter, is that correct?
Correct.
This is Exhibit P1. Is this a copy of that letter?
Yes.
All right. And what were you trying to accomplish through this letter?
My goal was to just establish dialogue so that we could have a legal understanding, shared understanding of what the true property line was.
And as part of this letter, it included a copy of the survey that you had performed. Is that correct?
Yes, that's correct.
Did the respondents ever remove the fence and other encroaching items after they received this letter?
No.
Was a second letter sent in response to the Thomases?
Yes.
All right. Do you remember when that was sent?
I believe June of 2024.
I'm going to pull up Exhibit P9. Is that a copy of that letter?
Yes.
All right. And what were you trying to accomplish in connection with this letter?
Again, shared understanding of where the property line was so that we could work toward a solution.
After the second letter, were the encroachments removed from your property?
No.
When were the encroachments removed from your property?
The last of the encroachments was removed yesterday.
And what was that?
Artificial turf.
And who removed that?
The defendants.
All right. Do you know when the fence was removed?
I believe January 31st of this year.
And what about
30th, late January.
And what about the bushes and other encroachments?
Late January as well.
So the problem's resolved now?
All right. And this lawsuit was filed in September or October of 2024. Is that correct?
That's correct.
Why did you feel like you had to file the lawsuit?
Well, the defendants had not responded to the letters that we sent, both letters, or offered access to come to a shared understanding of where the property line was at the rear of their property.
Were these encroachments causing any issues with the renovations to the landscaping that you wanted to perform in your backyard?
Yes.
How so?
Well, the design that I had come up with my landscaper required certain clearances. And it was a large project. And so I wanted to be able to do all of the work at one time versus having the people come out on separate occasions to do one part of the yard and then the second part of the yard once the boundary line was determined.
And to date, have you been able to complete those renovations to your backyard?
No.
Will you be able to complete it now that the encroachments have been removed?
Yes.
At some point, are you aware of any, no, strike that. Are you aware of any code compliance officers or anybody that has come out to your property?
Yes.
Can you tell me about that?
I discovered a report that was written by the city of Atlanta. In the report, it noted that a neighbor had called and reported a improper tree removal on my property. The report specifically said that that was her second request, and there was no violation found. Also in their report, the person noted that there appeared to be unpermitted turf and grading in the rear of the Thomas's property.
I'm going to pull up what's been marked as P13, which has been admitted. Is this a copy of that report that you found?
Yes, that's correct.
All right. And you can see here it says no violation found. Is that right?
Correct.
All right. You never had any conversations with Mr. Bedson?
No.
Okay. All right. What your property, Miss Martin, what is the total lot size?
Maybe less than half acre, 0.45, I believe.
And I'm going to pull up Exhibit P15, which has been admitted.
So the Thomases were telling
Is
on
this
the
a
Martins.
copy of the Fulton County assessor's website
But the
related
Martins,
to your property?
but the Thomases got in trouble.
All right. And it lists the primary site as 19,788 feet, or about 0.4543 acres. Is that right?
Correct.
All right. How much, in terms of feet, was the fence and the landscape encroaching on your property?
The distance varied from the top of the fence, which is where the stake was, to the back of the yard. So it could have been 2 to 3 feet at the top, my estimation, and maybe 1.5 feet at the back. So it was not a straight line from the street. It was diagonal, if you will.
What would you estimate the total percentage of your property that was affected by the encroachments?
Maybe 5%.
And the period of time that you were not able to use your property because of the fence, how long was that approximately?
2 years to the dates.
And if we can look again at Exhibit P15, I want to scroll down to the valuation portion of this that's listed on Fulton County. You can see that they have it from, the building value versus the land value. Can you tell me what the land value was between 2023 and 2025?
448,000 in 2023, 400,000 in 2024, and 400,000 in 2025.
Have you appealed any of those assessments?
Yes.
Okay. Is that possibly why it went down in 2024 and
Yes.
2025?
Yes, correct.
Objection, Your Honor. I don't know that this witness is competent to testify to tax assessors having anything. She's not a licensed appraiser. So I'm going to object on that basis.
She made the appeal. And it
All
went
right.
down.
Can I respond to that?
Yeah, Mr. Klein.
So this is a document that's already been admitted. I'm just asking her to read from it.
Okay. And and the purpose is you're trying to establish the value of the home here?
The value of the land that was affected.
Okay.
5% of that
All
is
right. Well, I'll just note,
$20,000.
I think to the extent I don't know if she'd be qualified to say exactly the precise reason it went down or varied or up and down. But I think she's just summarizing the exhibit that has been admitted. So with that, you can continue.
All right. Thank you. All right, Ms. Martin, did you incur any costs associated with the survey?
Yes.
How much were those?
In addition to the original survey, I spent $900 for 2 separate occasions for the surveyor to come out.
And then you're also paying Mr. Barnard $150 per hour for his testimony?
Correct.
All right. And Exhibit P10, is this a copy of a receipt?
Yes, correct.
And this is paid to Survey Systems?
Correct.
What other damage, or excuse me, what other out-of-pocket costs have you incurred?
I had to pay to have the fence company remove the boards from the defendant's fence.
And who did you pay for that?
I don't recall the name of the company.
All right, I'm going to pull up.
Works, maybe? I could have that wrong.
I'm going to pull up Exhibit P16, which has been admitted. Is this a copy of that receipt? Is that a copy of the receipt?
Yes, sir.
Oh, I'm sorry.
Yes.
Thank you.
So is she asking for the value of the property, which is $20,000 if it's 5% of 400,000. Does she want that doubled? So she wants $40,000 for the loss of the property for 2 years.
All right, I want to get to the counterclaim that's
Plus
been filed. Are
fees.
you aware of a counterclaim?
I don't understand what this expense is for.
This is, sorry, can you explain to the court what this expense is for?
The survey company had to remove boards to access or to be able to set the pin in the north back corner of the Thomas's property, and I had to pay for them to do that and put them back.
The survey guy said they didn't do that.
And that was in, that was during 2025 when the survey company came out there again?
Correct.
Okay. Your Honor, I am going to get into the counterclaim issue. I don't know if this is a good stopping break. I can keep going, obviously, but.
Well, let me follow up on that one more time. So was it the surveyor that told you that you would have to replace the boards that are getting removed just in this one section of the fence to place the pin, or is that something that your neighbors asked?
The survey company.
Okay.
I believe, I'm not 100% sure. David, you can, I'm not sure.
And so you paid to remove and replace a fence that you thought would just be removed entirely at some point if you wanted
To locate the pin, yes.
Okay.
To complete the survey, yes.
Why don't we keep going for a little bit?
Sure. Ms. Martin, are you aware of a counterclaim that's been filed in this case?
Yes.
What's your understanding of that counterclaim?
Currently, that I should trim branches that overhang my neighbor's property.
And that's
All
a
right.
tree that's located on your property?
Now we're getting to
What
the
kind
trees.
of tree is it?
I don't recall.
Has that tree ever been inspected?
Yes.
All right, when?
Most recently, the Thomases had the tree inspected in, I forget the date, but this year, March of this year.
I'm going to pull up what is Respondent's Exhibit L, which has been admitted. Have you seen this document before?
Yes.
And what is it?
The tree inspection report from the actual inspection that they commissioned.
And what was your understanding of what this report concluded?
That the tree was healthy, it should be maintained, but there were some branches that should be pruned back.
How would somebody access the branches to be trimmed that needed to be pruned? How would you access it?
My understanding is from the Thomas's driveway.
If they needed access to your property, would you be willing to allow that?
Certainly, but my understanding is that it could be trimmed solely from their side.
Right. And where do you get that understanding from?
The arborist.
All right, and you actually obtained a proposal yourself to get the tree branches trimmed, is that correct?
Correct.
All right, I'm going to pull up what's Respondent's Exhibit N. Is this that proposal?
Yes.
Why did you obtain that proposal?
Because I wanted to know first if the tree was okay or not, and if it was not, what if anything should be done?
It's a red oak. Red oak tree.
And this statement right here, that job assumes permission granted from neighbor to access driveway to set up large rotten branch as a hazard to people and property. What neighbor is this person referring to in this report?
The Thomases.
And so is that how you got your understanding it could be accessed by their driveway?
Correct.
Are you aware of any attempts that they've made to just cut the tree branches?
No,
Would you have any issue with them pruning the tree branches?
no,
All right, Ms. Martin, did you want to bring this lawsuit?
most certainly not.
And why did you feel like you had to bring the lawsuit?
The Thomases were not, in my opinion, cooperative with in response to the letters that we sent, 2 letters that spanned a period of 6 months.
And you are aware of the responses that the Thomases did send back to us, correct?
Yes.
Can you give the court an idea of what those responses said?
I believe the first one questioned things like, what is an iron pin? I don't recall the specifics, but it was just basic questions about what a survey is, why we needed it, etc.
All right, and did we respond to that?
Yes.
All right. And are you aware of any other survey being completed on your property or the Thomas's property?
No.
Can you just generally tell me how these encroachments have affected the way that you use your backyard and your own property?
Sure. Well, I have a son who's now 7 who has been, first of all, asking me for a dog. I didn't feel comfortable with the dog in the backyard because I have a slight pitch, and so I wanted, again, to do a fence in the front yard, which I could not necessarily do because of this gap in the Thomas's fence in my property line, and the property line. I think secondly, I again wanted to fix up the backyard, do a retaining wall in preparation for an event that I'm hosting actually this summer, and I have not been able to do that.
All right. How has this entire situation, the litigation, everything pre-litigation, how has that affected you?
It's awful. It's unfortunate. I think that we shouldn't be here.
I have no further questions, Your Honor.
Hey, here's Cross.
All right.
Might get spicy.
Mr. Miller, how much time would you anticipate for Cross?
Excuse me?
How much time would you anticipate needing for Cross?
I don't expect more than like 45 minutes.
Okay.
45.
All right.
Lunch, Judge.
I guess, any preference on going now or coming back?
Whatever the court desires.
Anyone?
I always like to keep going for honorable,
Okay.
but
All right, that's fine. We can have a later lunch. Why don't we transition over to Cross?
You pop up. There's.
I can just.
I'm gonna hand her package. In case you-
oh, sure.
I'll have it. Yeah.
Okay, that's a beautiful tree.
Miss Martin, I'm gonna hand you a packet of our exhibits. Might need to be photographed. I don't have all those in PowerPoint. Good afternoon.
Good afternoon.
It's the first time I've met you, I believe, isn't it?
In person, yes.
It's good to meet you, finally. I want to talk about the purchase of the house at 920 Wendover Drive back in April of 23, was it?
Yes, correct.
Now, first of all, when you purchased the house, you certainly visited before you went there to purchase it, right?
Yes,
And you saw this wooden fence that was on the right side of the backyard?
I saw a fence, yes.
You saw the fence sitting there, and did you assume that it was the Thomas's fence? Or did you know who owned that fence at the time that you bought the house?
Can you clarify which fence you're referring to again, please?
Excuse me?
The fence on the left or the right? I just want to make sure I understand.
The subject fence, the fence that's shown in this picture, which we've marked as Defendant's Exhibit O. That fence right there on the right side of your house, if you're facing your house from the street, that was the fence that you saw certainly when you visited the property, right?
Just to clarify, yes, there was a fence line that I saw, yes.
And you saw this fence when you were there before you bought the property, and you noticed the fence. Did you inquire as to who owned that fence?
No,
Why not?
I just did not.
But you were fully aware that there was a fence there, right?
Yes, correct.
And and you purchased the house knowing that fence was there, correct?
Correct.
And then you added this connecting fence, which is much newer than the older fence. Do you see that in Exhibit O?
I see the fence, but I did not add it. It was already there when I purchased the property. It
The
was
wooden
connected.
fence
Yes,
that was connecting to this old fence,
yes,
you didn't add that?
no,
That was already there before you ever purchased the property?
correct.
Okay. Now, could you go to the next exhibit, Q? Well, for.
Okay, gotcha.
In this picture, okay,
Wait for it. Okay. Ooh, there it is.
okay, you see Q?
Yes,
And that picture was the way this land looked that was up against the fence back in November of 2025, correct?
that's correct.
Excuse me?
Correct.
Correct. And for the time period between the date that you bought the property in April of 2023 and February of 2024, when you had your survey done on February 21st, you were certainly okay with the fact that you had a enclosed backyard with a privacy fence basically all around the perimeter of the property between you and the Thomases, right?
Was I okay with it?
Was that you took benefit from that, the fact that you had an enclosed private backyard for your son, right?
No,
Why not?
I didn't get a benefit from this, from having their fence. Maybe I misunderstood your question.
So let's go back to O just for a second, please. Your testimony is that fence, the newer fence, was actually already on the property when you bought the property.
Correct.
And you knew that fence was there when you bought the property, right?
Correct.
And you had a fully enclosed backyard at that point in time when you bought the property?
Correct.
And that's your testimony.
Correct.
Now, didn't you drive a benefit? How old is your son?
He's now 7.
He's now 7?
Yes,
Didn't you derive a benefit from having a fully enclosed private backyard due to these two fences that are shown in Exhibit O for at least the year of time before you had this survey done?
I'm not aware of what the benefit is. Sorry.
You didn't feel like you had a fully enclosed private backyard that wasn't any benefit to you?
I don't know.
Now, Could you show M1 through 8, please? You knew that there was an inspection done back in early March of the tree, right?
Correct.
And you have video cameras on the side of your house that probably taped the entire inspection, right?
I have cameras. Did they tape it? No,
But you have cameras on that side of the house, don't you?
I do, yes.
In fact, your P9, I think it's P9, is a invoice from ADT.
That's M1, sir. That's the offending tree.
I'll get back to that in a second, but there is an invoice in your plaintiff's exhibits for an ADT bill for like $3,000.
Yes.
And are you claiming that in this case?
I have not determined that with my attorney yet.
But it's one of your exhibits.
Correct.
We're putting up those video cameras?
Yes.
You're expecting the Thomases to pay for those video cameras that you put up on the soffit facing their driveway?
We have not,
Overall,
we have not determined that that's a request, no.
Okay. So looking at M1, could you bring that up?
M1?
Yes, please.
I can't, I don't know how to make, oh, wait,
On the side, basically.
is that good?
That's good.
Okay.
Now that is a picture of the tree, the subject tree, is it not?
Yes.
And that is a picture taken, as you can see, the inspector's there doing the work. And that is the way the property actually looked back in early March of this year, correct?
Correct.
And that tree is hanging over the Thomas's property house, isn't it?
Correct.
And you would certainly agree with me that that tree is a danger to their home and to their property and to the people that live there, right?
No.
You wouldn't agree with that?
I agree that the limb poses a danger, correct, not the tree itself.
Okay, I stand corrected. The limbs at the top, which are
Correct.
dead, according to the report that you just pointed to, those are a danger to the property, to the home, and to the Thomas's family. You'd agree with that, right?
Yes.
Now going on to the M2.
The camera's wonky there. I don't understand which house I'm looking at. Whose house is that white one? Is that the Thomases or the Martins?
Apologies, 1 second.
Defense doesn't do tech. If I were the witness, I would have responded to that question. Did you derive benefit from having a fully enclosed
share again.
backyard? Say, no, during the duration of that time, I was unable to enjoy the full benefit of my property because of the limits placed upon me by the illegal fence. That's the right way to answer that one. Did not have a benefit, I had a loss.
There it is. You get rid of that. Oh, okay. So M2 is another picture of the property, right?
Yes.
This is that strip. That's your top tier that's right next to what was the wall, correct?
The fence, yes.
What's that?
The fence,
That strip of, that swath of land is right next to where the fence was,
Correct.
correct?
correct.
And that's basically the condition that land has been in since day one until about 30 days ago when you covered it with mulch, right?
No, that's not correct.
Well, that's a picture from March 3rd, isn't it?
It is.
Okay. Can you go to M3? You see that? Do you see this in the bottom left corner? A piece of glass there in that picture?
No,
Go to the next picture, please. M4. Do you see the can in M4?
I see something. If you say it's a can, I believe you.
And there was broken glass and cans in that area? I mean, that's the swath of land that we're talking about?
Yes, the one I wanted to develop.
And that's the condition of it back on March 3rd of this year, correct?
Correct.
Now, the fence encroached by about 1.5 feet in the back and maybe 3 feet, 2 to 3 feet in the front. Is that correct?
That sounds correct, yes.
So what prevented you from developing the other 14 or 15 feet of that property?
Well, the project is a large project and requires heavy equipment, permits, et cetera. And so my preference was to do all of the work at one time versus having to come back out and then readjust potentially after the line was clarified.
And you're talking about that estimate that you got to build that tiered structure?
That is part of it, correct?
And that estimate wasn't obtained until August of 2025, wasn't it?
That's correct.
So that estimate was obtained after this lawsuit was filed in October of 24.
Correct.
Why wouldn't you get an estimate if you wanted to do something with that property or with that land well before the filing of this lawsuit?
Well, I did. This is one of the estimates that I received.
Well, the only estimate that's in evidence right now is the one that you got in August of 2025, correct?
Because that is the one I decided to go with, yes.
And you got that estimate, right?
Correct, yes.
Now, we can go through that survey, but you were here. You saw how your fence actually on the left side of your property encroaches on your next door neighbor on the left side, correct?
I heard Mr. Bernard say that, yes.
Okay. And you knew that.
I did not.
You did
know
not
that.
ever look at the survey that your attorney talked about so much with Mr. Bernard?
I did, but I did not know to that extent.
You didn't realize that your chain link fence on the other side actually encroaches on your next door neighbor on the left side of your property?
Oh, yes, I did realize that, yes.
Okay. And you haven't ever done anything about it, have you?
I've
That
had
chain
a
link fence is still
conversation
there.
with my neighbor about it. That so far, yes.
Now let's go to Exhibit F. That's the text message. Now looking at the first page of that exhibit, Exhibit F, are you there?
Yes,
You guys are sorority sisters, right?
that's correct.
What?
And you invited Brandy to some party of some sort in January of 24,
Yes,
and she couldn't go, but she explained why she couldn't make it to that party.
yes.
So you guys have been sorority sisters for how long?
I'm not sure. We probably are initiated at different times.
Excuse me?
We probably joined the sorority at different times, so I don't know the answer to that.
Didn't Brandy bring you a housewarming gift
Yes, she did.
This is so.
when you moved in?
I received a flower, yes.
And did you feel like you had a good relationship with her at that point in time?
Yes,
Now let's look at the second page. And you certainly agree that the tree branches posed a serious danger to Brandy and Cedric's home and their family, right?
could you repeat the question, please?
You already certainly agreed that the tree branches, maybe not the tree, but the tree branches were what was falling on their roof, on their driveway, on their entrance to their home. And you certainly would agree with me that that is a danger to their family and to their home, right?
I agree that the branches could pose a danger. I do not know that my tree caused damages to their roof.
Well, you certainly read the text and you received it on February 4th of 2024, right?
Correct.
And that first page says that, I hate to hit you with this, but I'm wondering if the people who sold you the home talked to you about the dead tree that overhangs between our driveways. The reason I bring it up is that for the time we have lived in our house, 5 years now, that tree has dropped dead limbs on our house and driveway and damaged our roof, cars, and other parts of our house. Did you believe that, or did you just think that was a lie?
I did not know.
Didn't you feel like that was a valid concern that Brandy had?
Certainly.
The history of trees in this area is pretty brutal. The house that was on our property before ours was built was literally cut in two by a fallen tree. Because of our concerns for further damage with that tree, we sent a certified letter to the previous owners after we had appraisal done of the trees in our property and the surrounding trees. I mean, did you find any reason not to believe any of this?
At the time, again, because of the legal language that was used, citing code references, etc., that is not my area of expertise, so I did not know what to make of what has been said. All I know I've seen is stories on the news about trees falling and what, is supposed to happen or who's supposed to be responsible for resolving it.
And this was coming from your sorority sister.
Correct.
So didn't you think that Brandy had a valid concern?
Yes.
Wouldn't you express that kind of concern if you had the situation that Brandy had going on for 5 years?
Yes, but not in a 2-page text message.
Well, let's get to the third page. Did you discuss with the prior owners the fact that they had to take care of tree limb damage to the roof of the Thomases?
No.
Did you discuss anything with them about this tree that was posing a threat to their Thomas's property as early as 2021?
No.
Why didn't you tell Brandy that?
Again, the long exchange over text message and the legal references, citing regulations, it's not something I felt competent to discuss over text message.
Well, why didn't you just walk over to her house?
First, at the time, I was at dinner, and so I couldn't have just
How
walked
about the
over.
next day?
I was not comfortable having a conversation with someone, a friend, as you say, who would engage in a conversation about the legalities of a tree over text message.
And this was coming from your sorority sister.
That's correct.
Now, on the next page, page 4, she cites to the Georgia regulations, which she is aware of, but she also says, I'm not requesting anything at all from you regarding the repair or any damages that have been done since you have been in the home. Soro, you and your family have done so much to make the property better. Don't you think that was kind of a nice thing to say from a neighbor?
Yes.
Don't you think that's kind of a friendly way to say, let's work this out?
No, I do not.
Why not?
Discussing legal matters over text message is not something I'm comfortable doing with anyone.
Even with the sorority sister.
Even with the sorority sister.
Now let's go to the next page. Page 5. However, I would like you to address the tree, and in order to make sure my house doesn't sustain any further damage, I'm going to place a copy of the letter that was sent to the previous owners in your mailbox. Now, did you get that letter on
Yes.
March 27th?
Yes.
With report?
Yes.
And did you have any reason to think it was made up?
Made up? No.
I mean, that was an official certified tree inspector, peace tree arborist, that had been out to the property and said, this tree is definitely a hazard. It needs to be, a level 3 inspection needs to occur to it, right?
I don't recall if he said a level 3 inspection was required. What I do recall he stated was that he performed the analysis above the fence line and he did not have access to the trunk of the tree.
But didn't you feel like at that point in time on March 27th that they sent you this letter and they sent you this report that it was certainly a valid concern that they had about these dead tree branches?
Yes.
And she goes on to say, also, if you have any trees on your property that are posing an issue to your home, please let us know and we will have them promptly removed. Do you remember reading that?
Yes.
Did you not feel comfortable talking to her about this when she's offering to take care of any trees that are posing any kind of danger to your property?
I did not feel comfortable, no.
Now, the next page, page 6, says, hi, Soro. I don't really get into outside stuff, but I did share your message with Keith. He said he's available to talk this weekend. So that was your response back on February 4th or 5th of 2024, right?
Yes, correct.
And there's nothing in there about, legal stuff. I don't get into legal stuff. There's just, you don't get into outdoor stuff, right?
That's correct.
But you did get this estimate. That's outdoor stuff, isn't it?
Do you mean the estimate for my property?
Yeah.
Correct.
So you do deal in those outdoor stuff, but you don't deal in outdoor stuff having to do with trees?
Perhaps.
Excuse me?
Perhaps. I don't know how to answer that question.
Did you tell Keith? Did you tell Keith about this valid concern of Brandy's?
We're watching the fence and tree case.
I told him about her text message, yes.
Did you show the text message to Keith?
I don't recall.
You don't recall?
I don't.
So even though you felt like this was a valid concern, you didn't show him to Keith so he could talk to Cedric maybe and see what we could do to work it out?
I didn't say I didn't. I don't recall if I did or not.
Okay. Now,
she's been well prepped.
Didn't you have some trees removed on your property on March 23rd of 2024?
Yes.
And do you know what Keith told Cedric when he approached him about this tree issue?
There it is.
It's offered for a non-hearsay purpose.
Explain her conduct, Your Honor.
All right. Overruled.
Thank you.
Could you repeat the question, please?
Do you know what Keith
Do you
told
know
Cedric?
about Keith's and Cedric's conversation?
Yes, I know that they had a conversation, yes.
Was that on March 23rd when you guys were having trees removed from your own property?
I don't recall the date.
What do you recall about the conversation?
Actually, not much. I just know they talked.
Do you know what Keith said to Cedric?
I do not.
Do you know that Keith said, well, I'm going to get a specialist to take a look at that tree?
I do not know that, no.
Keith didn't ever tell you that?
No.
How many trees did you remove on March 23rd?
Maybe 3,
3 trees?
perhaps. I don't recall the specific number, but
Now, knowing Brandy's concerned that you consider to be valid, since February 4th of 2024, why wouldn't you just walk over to her house and say, let's discuss this and let's get it resolved?
again, I am not comfortable having legal conversations, conversations with people when they start quoting legal doctrine, because I do not know if that's true or not. And I, again, just was not comfortable having that conversation.
Did you ever tell Brandy that?
No,
Why not?
Jenny, that would be
because at the time,
That's funny.
I decided to get an attorney to represent my concern because I wouldn't have wanted to approach her with something that I did not have a legal basis for, a valid legal basis for.
Well, how about get the attorney and say, let's all meet together with the attorney and let's work this out.
Well, that was the purpose of the first letter and the second one.
So you decided to lawyer up first and then send a letter saying remove the fence.
Yes.
Well, that's not exactly what the letter said, is it? But before I get to that, the last document in that exhibit is a picture. And this picture was enclosed with the text message, wasn't it?
Yes.
And it shows the damage to their lamp over their garage door from your tree limb.
I do not know that to be correct.
That's what Brandy said happened, right?
That's correct.
She wasn't asking you to pay for it, but she was showing you this damage. Did you have any reason to believe that that was not the damage that had just occurred in early February of 24?
I did not know.
Did you have any reason not to believe this?
And with no evidence, yes, I had all the reason not to believe because I did not know if that was caused by my tree or something else.
Isn't this picture and isn't the statement from Brandy enough?
No.
Why not?
All kinds of things can happen to a lamp.
I mean, this is your sorority sister you're talking about.
It is.
Yeah, we're going to get kicked out of the sorority here in just a minute.
Now, during the entire month of March, you never attempted to talk to her, contact her, text her, or anything, did you?
No.
Are there
And
rules
the reason
against
would
suing
be
your sorority
because
sister?
she cited some statute in her original text.
Correct.
Any other reason?
No.
And you got your survey done on February 21st of 24, which would have been about 2.5 weeks after the text from Brandy, right?
Correct.
And I suppose that survey had nothing to do with the text from Brandy on the 4th, did it?
No, because I contacted the survey company in January of the same year, initially.
Well, Mr. Bernard said he was contacted on February 21st, did he not?
Perhaps he was as the supervisor, but I emailed the firm in January to initiate the survey.
So the only reason why you didn't try to work something out was because Brandy had cited a statute in the original text. Is that correct?
Yes.
That's the only reason.
Yes.
Let's go to Exhibit N, which is the estimate you got.
Can we see this one, please?
Now that estimate was obtained on March 13th of 2025, right?
Yes.
And it was obtained because you wanted to see what it would cost to prune the tree back?
No.
Why was it obtained?
The estimate or the proposal was obtained for me to understand the condition of the tree and what, if any, work needed to be done to it.
Okay. And the estimate says large rotten branch is a hazard to people and property.
Yes.
Did you believe that?
Yes.
And that was March of 25. That was actually a week after the answer and counterclaim were filed in this case. Did you ever send this to Brandy?
No.
Did you ever authorize your attorneys to send that to Brandy and say, listen, $1,300 and we're done with the tree issue?
Yes.
And why didn't you offer to pay $1,300 in March of 25?
Well, this lawsuit had been going on for a year. Almost a year.
No, the lawsuit was filed in October of 24.
At 6 months. It had been going on for 6 months. And because the counterclaim was filed, I thought we should handle it through the legal process.
Why didn't you simply offer to take care of the pruning back of the tree and then Brandy would remove the fence. Why not do that right from the beginning?
I don't have an answer for that. I did not see, I don't have an answer.
All right, let's look at this letter that your counsel pointed out, which we have as Exhibit G2.
G2, it's like a G6, but less. M4 is really getting old, sir. If you can just change that picture, that would be just great. Or just put it down. Take it down off the screen. This is a bench trial. It's about fences and trees. It's critical stuff. It sounds like
Now,
they both have claims against each other.
This letter in this third paragraph states that that you will allow Miss Martin's surveyor to access your property in order to locate an iron pin located on the northwestern corner of your property to more accurately depict the location of the boundary line between the two properties and mark the boundary line with flags. Do you see that?
Yes.
Now, do you know if the boundary line was ever marked with flags?
There were 2 stakes placed that had flags on them on that side of the property line, yes.
There were no flags on that boundary line, were there?
If you don't recall, if you don't refer to the pink tape as a flag, in my opinion, that's a flag.
There was a wooden post
with the pink
flag
flag wrapped
tape
around
on it.
Yes.
And then there was a survey pin in the
Tape
back.
is not a flag.
But there were no flags coming down that boundary line, were there?
No.
There were never any flags coming down that boundary line, were there?
No.
That's correct, isn't it?
That's correct.
So on April 23rd of 2024, your attorney's letter says that, first place, we need to get access to the property to locate this pin to make the survey accurate, right? That's what it says there.
Okay.
Is that right?
I'm sorry, where are you reading from?
The bottom paragraph. Says to more accurately depict the location of the boundary line. She didn't have access to that pin in the back, and the reason was because the fence was on top of it. That's why you had to pay to have it removed, right?
I am not aware that the fence was on top of it. I don't know that.
But you're aware the fence had to be removed
Correct.
to get to the pin, right?
Correct.
And Mr. Bernard didn't know anything about that, did he?
I don't know.
You heard his testimony.
I did.
He didn't know anything about removal of the fence, did he?
I don't recall what he stated.
Now, your next sentence from your attorney on April 23rd, 2024 says that once the updated survey has been completed, after viewing said iron pin, that you move your fence and other items back to your side of the boundary line. So, wasn't that survey not completed under Mr. Bernard's testimony until as late as October 25 last year?
No, now I did hear him say it was complete. Both surveys were complete, according to his standards during his testimony today.
Well, he had to re-access the pin, and the pin wasn't accessed until September 30th, 2025, correct?
Yes.
And that access agreement that we mentioned with Mr. Bernard that he didn't know anything about, weren't you given access to that pin as early as January or February of 25?
I don't recall the date.
Well, this access agreement that had to be entered into wasn't entered into until July of 25, correct?
I don't recall the date, but yes.
Well, it's in evidence.
Okay.
It's dated. And then Mr. Bernard didn't get out there until the end of September of 25.
Yes.
Do you know why it took literally 10 months for him to get out there and actually access that pen so he could more accurately depict his survey or complete his survey?
I do not know why.
And you know that the fence was removed in January of this year, right?
Yes,
And the turf has been removed as of yesterday.
yes,
And the bushes were removed about a month ago, right?
yes,
So everything's gone.
yes.
Now, once the fence was removed, why didn't you just go out there and remove the turf and back down the bushes and go ahead and start your project?
Well, I had surgery, and so
I'm
I've
sorry.
not had the time to do that.
Well, you do know that the completed survey was never provided to us until October 30th of 2025.
I do not know. If
Well, I
that's
have an
right.
email and evidence that proves that it was not provided to us until October 30th of 2025.
Okay.
Now, getting back to Exhibit F. You can take that down if you like. Thank you. Well, actually, it's Exhibit 1 of the attorney fee side of our exhibits. Now, Exhibit 1, are you there with our exhibits? Defendant's Exhibit 1, it's the last text. Do you see that?
I'm getting there. One moment.
She's a well-prepped witness. Yeah, I don't miss M4 anymore.
Yes, I have.
Bye-bye.
Now, did you receive that text on April 24th, 2024?
Yes,
And it said that, left you a voicemail, would you be glad to speak to you about your concerns regarding the fence and happy to look into it. I won't be calling your attorney, though. We could have a neighborly conversation about this and address any of your concerns. We were not given the courtesy of a discussion ahead of legal engagement. You would agree with that, right?
I do not agree with that.
Did you ever give Brandy an opportunity to discuss this prior to hiring Mr. Klein?
No, because she.
Because of that statute site.
Correct.
But it's true that you didn't try to discuss this with Brandy in any way, shape, or form before April 24th, 2024.
That's correct.
We were not given the courtesy of a discussion ahead of legal engagement. Please let us know when you would like to stop by. We would also like to talk with you about the tree. So why not take Brandy up on her invitation?
Well, sir, this text was sent at almost 10 o'clock at night. It started on my son who was asleep. And when it was sent after repeated phone calls at this time of night, followed by a text. And I saw it the next morning and I was taken aback.
So the repeated phone calls where Brandy left you voicemail messages too, didn't she?
Correct.
And you never responded to any of that, did you?
Correct.
You just lawyered up.
Correct.
Isn't it true that Brandy's door was always open through this open invitation to discuss the situation and resolve it as neighbors do?
In my opinion, no.
Why not?
Because neighbors don't speak like this to neighbors and cite legal statutes and regulations and send text messages this is long when you want to have a neighborly conversation, in my opinion.
And those letters you discussed about in the summer of 2024, none of those letters that were sent back and forth between Brandy and your attorney discussed this tree in any way, did they?
I think there were references to the tree. Maybe on her side, but there were references in the
Are
community.
you sure of that?
No, I said I think. I'm not 100% sure.
Well, and those letters were just questions from Brandy as to this survey and how it was incomplete and what a pin was and those kind of things, right?
I don't understand your question.
Well, you said before that because of the questions in the letter that you felt like there was no resolution coming, and so you authorized filing of this lawsuit in October of 24, did you not?
I don't know how to answer your question. Could you maybe restate it? I'm not sure what you're asking.
Well, I thought you said before that there were questions that were asked about, basic questions about a survey pin
Yes.
in these letters from Brandy to Mr. Klein, right?
Yes, correct.
And in those letters, Brandy was simply asking, what is a survey pin? How does this work? Is this survey any good because it's dated 2013 and those kind of things, right?
Yes.
And how would that make you think that you have to file a lawsuit because of those questions that are being asked by Brandy of Mr. Klein?
Well, the first response alone did not make me think I needed to file a lawsuit. There was a second request as well. And the request was to allow access to locate the pin, which was not allowed or granted. That was the request, to allow me to complete the survey as a neighbor.
So you never took it upon yourself simply to walk over to her house and say, let's work this out?
No, sir, I did not.
Isn't it true that the Thomases never, ever refused to move their fence, though, right?
I saw that the fence was removed in January of this year.
But isn't it true back in February, April 24, June, July, August of 24, they never, ever said, we're not moving this fence. In fact, they said just the opposite with their first attorney in November of 24, did they not?
I don't recall.
In November of 24, November 18th of 2024, Melanie Nealis suggested that if you prune the tree back, which would cost all of $1,300, we would remove the fence and we don't even need you to complete the survey, which was uncompleted in November of 2024. Were you aware of that settlement offer?
I want to put an objection just on the record that this compromises settlement negotiations and should not be admissible or discussed during testimony under OCGA 24-408.
All right, well, having reviewed Rule 408 and the case law cited by counsel and consulting with Milich's rules on Georgia Rules of Evidence, it does show it's fairly explicit that evidence can be relevant to other matters, such as supporting and explaining a party's petition for attorney's fees. So objections preserved but overruled.
Thank you, Your Honor. So were you aware that in November of 2024, your attorney and Ms. Nealis had several emails between them that Ms. Nealis is prepared to testify to, that was an offer of, we'll remove the fence if you'll just prune the tree back. This was November of 2024.
I'm aware of the communication. That is not all that was requested, as far as my understanding is.
Go to Exhibit 5. Defendant's Exhibit 5.
Sounds like she's after the money. What do you think?
Third paragraph of that email. You see it?
Yes.
My clients nonetheless have a desire to put this matter behind them amicably and quickly. Purposes of settlement only and without any admission of liability, my clients will agree to move the fence no later than February 28th of 2025, subject to the availability of qualified contractors. In exchange, my clients request that your client hire a professional tree service to trim the offending tree to the satisfaction of the arborist to be retained by my clients no later than February 28th, 2025. Each party will bear their own respective cost. There's nothing else in there about anything but trimming the tree back and moving the fence, is there?
There is a statement about each party bearing their own costs. That is a request.
So you bear your costs, they bear their costs as
Yes.
far as any attorneys.
Yes.
But the main thrust of that settlement offer was simply prune the tree back for $1,300 and we'll remove the fence without a completed survey, right?
Sir, my understanding is that the survey was complete. The first and the second one were marked complete by the survey company. And at that time, I did not think it fair that we both that I eat attorney's fees for this matter.
So you refused the settlement, didn't you?
Yes, correct.
And certainly the pen was never accessed until September 30th of 2025.
I believe that's correct, yes.
That was because the fence had to be removed, right?
Correct.
Now, were you aware of the 3 extensions of time to file an answer here and file a counterclaim?
Yes.
And weren't you aware of the fact that those 3 extensions were specifically given to try to work out a settlement?
I did not know the reason.
But you knew there were 3 different extensions.
Yes, correct.
All the way from November until March to try to work out some sort of settlement.
I knew there was an extension. I did not know the reason.
Now, in February of 2025, February 18th, you called the police, didn't you?
Yes.
And you called the police because you alleged that Brandy's landscapers were throwing trash on your property, didn't you?
I don't know that I used the word throwing, but generally speaking, yes, they were landscaping over the property line, yes.
And they were throwing trash on your property. Isn't that the allegation that you told the police?
I don't recall using the word trash.
And didn't you have a conversation with the officer where you were yelling and screaming at him because he wouldn't do a report?
Conversation, yes. Yelling and screaming, no.
Okay. And didn't you call his supervisor to try to get a reprimand of him because he wouldn't do a report?
No.
You didn't call the supervisor?
No.
Are you sure?
Positive.
Now,
Maybe Cedric.
this exhibit that you talked about earlier, P13, this letter, which is the Code 508 investigation, the 920 Wendover. How did you find this?
On the City of Atlanta's website.
So you searched the City of Atlanta's website back in, it's like it's dated June of 2024.
Yes,
And do you know who actually made this complaint?
I do not.
So this could be not even the Thomases, right?
I don't believe that's a possibility.
Do you know whether or not the Thomases are the one who made this complaint, or is it someone else?
Do I know definitively? No. But based on his comments about artificial turf and grading, neither of my other neighbors have that in their backyard up against my property. So I don't know who else it could be.
Well, there's no indication on this P13 as to who called, is there?
Correct.
And if Brandy and Cedric both deny that they made this call, you would have no evidence to prove them wrong, would you?
No.
Now, the independent or the access agreement took a very long time for it to be worked out and actually signed in July, did it not?
Yes,
And were you aware that you were given full access to the property as of January, February of 2025?
I do not know that.
And you then had called the police in December and January of 2025 and 2026, right?
Which date were you referring to?
Were you called the police because the girlfriend parked in the wrong direction?
No, sir.
Did you call the police because of that?
No, sir.
So you didn't call the police then?
No, sir.
Do you know why it took so long for this access agreement to actually be signed from January of 2025 until July of 2025 when it was actually finally signed, and then the inspection to locate the survey pin didn't occur till September 30th of 2025? Do you know why it took so long?
I do not know.
After this, I think I'm going to get rid of all the trees on my property. Worried about the neighbors suing me.
Wouldn't you agree with me that by hiring an attorney and sending a letter like this was escalating this situation to a potential lawsuit as opposed to trying to work it out with your neighbor?
No, I do not agree with that.
Why not?
The request was to complete the survey, and if the findings, resulted that there was an encroachment, that the items be removed. And that was my expectation, that we would work through the survey and respond accordingly, whatever it turned up.
And you certainly don't blame Brandy nor Cedric for the delay in actually getting this access to the survey pin, do you?
I don't know.
And you refused to settle this matter pretty much at every turn before it was filed into a lawsuit in October, right?
My request as a homeowner was to have the items removed from my property.
So, but for the fact that you had some attorney's fees that you chose to retain a lawyer for, you would have settled in November, prune the tree back, and then they would remove the fence? Is that correct?
I can't answer that. In November, the request was for me to remove the tree in its entirety, if I recall correctly, not prune it back. The pruning request came much later.
Taking a look at him.
M1.
Defendant's Exhibit 5. There's nothing in there about taking out the tree, is there?
Which item are you looking at again?
Paragraph. Third page.
Which exhibit? I'm sorry.
Clients will agree to move their fence no later than February 28th. In exchange, my client's request that your client hire professional tree service to trim the offended tree to the satisfaction of the arborist. There's nothing about taking out the tree in November 18th of 2024, is there?
I'm sorry, sir. What exhibit are you looking at again?
I'm looking at Defendant's Exhibit 5.
Okay.
Third page.
Is this the same paragraph you just read? I just want to make sure I'm looking at the right exhibit. The email?
Yes. November 18th of 2024. Email from Melanie Nealis to David Klein.
And the question again, I'm sorry.
And the third paragraph has nothing about removing a tree. It says simply trim it back, correct?
Yes. Along with other things.
Along with the fact that the parties take care of their own cost, right?
Yes.
And that was the part that you were unwilling to agree to, right?
Correct.
But don't you think it's reasonable considering the fact that Brandy had a valid concern that you throwing the tree back for $1,300 at that point in time, and they would remove the fence and pay for the removal of the fence. Don't you think that's a reasonable settlement?
My understanding from the arborist is that I cannot go on their property to do anything to my tree because it overhangs their property.
But they were willing to allow you on their property on November 18th of 2024, were they not?
I don't know that.
That's what the offer says, does it not?
That I was allowed on their property, I don't see that written here.
Excuse me?
I don't see that written here, that I could have access to their property.
Ma'am, don't you agree that you have actually been the one who has been so stubbornly litigious?
I do not.
Don't you agree that you've been the one who has caused all this unnecessary expense and trouble?
I do not.
And you're not a
your
licensed
sorority
state of
sister.
Georgia certified general appraiser, are you?
I am not.
And you don't know whether or not those type of appraisers that are licensed even use tax assessor mass appraisals in determining fair market value, do you?
I do not.
And as far as that 5% that you gave before, what is that based on?
An estimation that I heard from one of the surveyors.
Okay, so that's not based on any kind of calculation that you did.
No.
That's based on hearsay.
My understanding of their assessment, yes.
No further questions, Your Honor.
All right, let's see if we can finish with Ms. Martin. Do you have any redirect, Mr. Klein?
I do, Your Honor. All right, Ms. Martin, was there any indication that the Thomases have ever tried to prune the tree that we're talking about, that since you've been in the property?
No.
Would you have cared if they tried to prune the tree from their side of the property at any time?
No.
There were a lot of references to you two being sorority sisters. Can you kind of explain how good of friends you are? Or like, what does that mean that you're sorority sisters?
It means we are a member of the same service organization. There are 350,000 members across the world, and we each join at different colleges or places in our lives.
Okay, so you didn't go to college together?
No.
Okay. So you were joining different, or the same sorority at different colleges?
Correct.
All right.
So they never even met each other.
Do you get nervous or anxious when legal issues are brought up?
Yes.
Why is that?
Because I am not a lawyer, and I don't want to say or do anything to that's not correct.
Have you ever had to deal with legal issues in the past?
Yes.
Did those cause you nervousness or anxiety?
Yes.
Did Mrs. Thomas ever come over, knock on the door, and try and talk to you about this situation?
No.
We saw a lot of text messages, but did she ever try to call you, to your recollection?
After the lawsuit was filed.
Now, I want to pull up what is already in evidence as Respondents Exhibit 2. All right. Do you recall us receiving this letter in response to our initial demand in May of 2024?
Yes.
All right. I'm going to scroll down to the end of this document.
It's got a lot of screenshots.
And you'll see this letter that's attached. Do you recall seeing that letter before?
Yes.
Was that the letter that was dropped off in your mailbox? Or what? How did you receive that letter before?
It was put in my mailbox, yes.
Okay. Was it put in your mailbox around March 27th of 2024?
Yes.
Do you know who put it there?
Miss Thomas, she said she was going to in the text message.
Okay. And I'm going to go ahead and just read this portion right here. As my wife Brandy stated to Brianka, we are not asking for damages to be paid at this point. However, allow this letter to serve as notification that going forward, unless this tree is properly addressed, paying for damages caused by this tree will now transfer to the Martin household. Do you recall reading that around this time period?
Yes.
What did you think of that?
Made me nervous and anxious, and I did not want to have the conversation without the proper representation.
And
Any conversation about tree or other things.
And shortly after you received this letter, you retained my law firm. Is that correct?
Correct, yes.
And then also here, it says, unfortunately, the seller of your home sold the house without addressing the tree, therein transferring the liability to address this to you. How did you feel upon reading that at the time?
Nervous, anxious, unsure, all of those things.
Does this look like a friendly letter from a neighbor to you?
It does not.
How did you feel? How did you receive this letter when, what did you feel like when you received this letter?
I felt like there was a attempt to place blame or liability for a matter that I had didn't have much information about.
And then I want to pull up Respondent's Exhibit 4, which is already in evidence. This is another response that we received once we sent a letter. Do you remember this response in July of 2024?
Yes.
All right. And this is from the Thomases, is that correct?
Yes.
And so in this letter, they say we decline the option to use email communication. Is that correct?
Correct.
And under Section 1, they say the Martins may not have access to our property to validate an assessment that they have updated multiple times. There have been multiple assertions about the validity of their survey. This should be sufficient for them. Do you remember reading that around this time?
Yes.
What did you understand them to be saying there?
They would not allow the survey access to their property, the surveyor.
And then under Section 3, it says, because we have not had our own independent survey since we moved in, we will be commissioning one ourselves. Do you remember reading that at the time?
Yes.
Have the Thomases ever commissioned a survey to your knowledge?
Not to my knowledge.
They've never shared a survey with you?
No.
You are banished from the state of Georgia.
She's been well coached on this one, I think. Prepared.
I'm going to go ahead and pull up Respondent's Exhibit 5. You never had any communications with Miss Nealis, correct?
No.
And if you look at this, she first reached out on November 11th of 2024. Is that correct?
Yes.
And by that time, we had already filed a lawsuit. Is that correct?
Correct.
Had you incurred attorney's fees in sending letters, drafting a lawsuit, having the lawsuit served at that time?
Yes.
And back in when we were in the letter writing phase, what did you believe? If you could access the property, get this survey done, do you think there could have been a resolution at that time?
Yes.
And yet in July of 2024, we weren't allowed access. Is that correct?
Correct.
So why did you feel you needed to file a lawsuit at that time?
Because the survey could not have access to their property, and they did not allow access to complete the survey.
And by the time that we received this settlement offer from an attorney on November 18th of 2024, do you know how much in terms of attorney's fees you had incurred by that point?
Not exactly, but more than I wanted to spend.
And they were also asking you to trim the tree, is that correct?
Correct.
And within this settlement offer, it says in parenthesis, to the satisfaction of an arborist retained by my clients. Is that correct?
Yes.
So you didn't know what arborist was going to be retained?
No.
You didn't know what that arborist was going to recommend?
Correct.
And at the time you had, the only thing that you had was a report from 2021 from Peachtree Arborist, right?
Correct.
And that indicated that you needed to actually remove the entire tree, right?
Correct.
All right, no further questions, Your Honor.
All right.
Recross on those points.
Recross.
Thank you, Your Honor. Very quickly, Ms. Martin, the first paragraph of that letter, Defendant Exhibit 2, states that it should be noted this is the first time we are hearing of the Martins' concerns via letter from your law firm. So you had never brought it up with the Thomases about this encroachment, had you?
No.
And why was that?
Legal references in a text message plus additional legal references and accusations of liability in a letter that was placed in my mailbox.
You certainly chose to retain counsel, did you not?
I did.
And Brandy Thomas did not retain counsel in the summer of 2024, did she?
I don't know when she retained counsel.
Well, she's the one who's authoring all these letters we're talking about, right?
I suppose so, yes.
And she says, Mr. and Mrs. Martin never engaged us in conversation, although we have invited them to do so at any point. Isn't that true, that they invited you to do so at any point?
Any point after speaking to me over text message with legal references and sharing a letter in my mailbox placing liability for a matter I had no information about.
And leaving several voicemail messages for you on April 24th.
That's correct.
Which you never responded to.
Correct.
It says never engaged in this conversation, although we invited them to do so at any point, at any time, should they need anything, whether assistance or a concern. Does that sound like somebody who's trying to threaten you with legal action?
In the context of receiving a text message with legal references and a letter with legal language, yes, it does.
Well, you never responded to that letter of 3/27/24, did you?
I did not.
You had your attorney do it.
Yes.
And as far as Defendant Exhibit 5 or 4, once again, this is a letter from Brandy, correct? Or Cedric and Brandy. So as late as July 25th of 2024, Brandy and Cedric were not retaining any attorney to represent them, correct?
What's the date again? I'm sorry, I can't see it.
Defendants Exhibit 4.
That's correct.
July 25th, 2024 letter.
Yes, that's correct.
So that's from Brandy and Cedric again.
Yes.
And they are still trying to get some kind of relief from this dangerous tree. Would you agree with me that was, in fact, a danger as far as the branches?
Listen
right?
to the wording here.
Sorry, what's the
Posed
question
danger.
again?
They were still trying to get some kind of relief from this dangerous tree that you've already agreed with me has dead branches on it that fall on their house, on their driveway, and potentially on their family.
That's a loaded question. I agree with some of what you said. I disagree with other parts of what you just said.
Well, there was never any response to the July 25th, 24 letter, was there?
Response from whom?
From your attorney or anybody else?
Not that I'm aware of.
And you were fully aware of this letter on July 25th, 2024, right?
Yes. I don't recall the dates of when. I know we responded to them. I don't recall if it was for the first letter or the second one. I don't recall.
And she says that she'd like to get her own survey, right?
Yes, which I have not seen.
Which what?
I have not seen.
Well, why didn't you have your attorney contact her before you filed suit and said, have you got the survey? Is it done? But you filed suit instead in October of 2024, right?
What's the question again?
After the letter of July 25th, 2024,
Yes,
where Brandy says she wants to get her own survey
yes.
to verify your incomplete survey. Why didn't you contact her before you filed suit and said, do you have the survey? Can we work this out?
I don't know the answer to that question.
You didn't make any contact, did you?
I don't know the answer to that question.
Well, your attorney didn't make any contact to her before he filed suit in October 2024, right?
I don't know the answer to that question.
No further questions, Your Honor.
All right, ma'am, you can step down.
Thank you.
All right, why don't we'll take at least 40, 45 minutes. If parties come back earlier, we'll get started earlier. So let's be back here no later than 2:15. We got that cafeteria on the first floor if you want to just have a quick bite. And again, we can start as early as 2 if you're back here by then.
Judge, do you have a picture of what's on the menu?
Well, let me first close this loop. Mr. Klein, do you anticipate presenting any further evidence?
No, Your Honor.
All right, so at this point, the petitioner rests, and we'll take it back up at the latest 2:15. We're in recess.
Thank you.
Can you show us a picture of what's for lunch, Judge? Maybe? That'd be great. He usually does have a little graphic we can see of lunch.
Yeah, you can, but they'll probably lock it up. So I'm fine.
What do you think? What are your thoughts? Are you team fence or team tree? Which I'm not sure which side you're on.
Allowed to leave our stuff here?
Excuse me?
Are we allowed to leave our stuff
Yes.
here? Okay.
Absolutely.
Might not be here when you get back, but you're allowed to leave it. I'm invested. I think Panda Express. Judge, come on, give us a lunch picture.
Yeah. Improvements to that house. Bad. We probably find pictures to show. That was never there. I will not believe she did that.
Testify to it.
Yeah.
I don't think we should be hearing this part.
Yeah. But she had to lie and perjure herself. That's over the top.
It might get spicy after lunch. Just saying. Might get spicy.
They're fine.
Maybe him up first.
Okay.
And then finish with
Oh, where we going?
I don't know.
Saturday.
I don't know where you want that.
Okay, so Devon Jackson, I'll tell you about.
You.
He got grandkids.
Oh, okay. Yeah.
And then the guy, Grant Ross, they just transferred from
I
Congress
used
to us.
43 minutes.
He's a codependent on the gang case. So because Devon Jackson had
Cross.
those older
We got
cases, all the
only 20
codependent
minutes,
cases now came to us.
Awesome. And guess what? It's a conflict now because somebody in our office had one of the other co-defendants in the game.
The
Oh
other thing
my
I was
God.
thinking is to
So,
that point
I
of
don't
why
know
they could
who's
not
gonna
have
end up
access to the yard.
I mean,
So exhibit
guess what?
P5
It's game.
shows
Two
that our
conversations.
property was under construction at that point. There was a ton of building material. That was an active job site. And so it would have been unwise of me at that point
Yeah.
allow access
Okay, I didn't know like.
without some sort of agreement there.
All right. You're right. Just stuck down real quick.
Gonna write all this down. You used 23 minutes of your time
So-
on cross.
P5.
P5, yes. You see this material here? This was all material that was being used to construct our pool.
The pool.
So that also is why I was like, wait, time out. You know, she's incredibly litigious. They've not been responsive to requests. It would have been great to speak to her on any occasion. And so there were many reasons why allowing somebody on the property for a purpose I didn't fully understand without some prior thought or continued thought. Also why I was like, well, oh, we have the pool survey.
Hey, Can they still hear us back in the back?
Mm-hmm.
Because it's off.
Oh, can I turn it off?
Red light is, when the red on, yeah, it's on right now. You can tap. Yeah, touch it. Yeah, red light is something.
Can they still? Are we still?
You guys want to stay here, you can. We got a conference room right here. You guys can do.
Okay. That'd be great.
Let's move our conversation to the conference room, maybe. Ms. Thomas, and talk about perjury there. That's a good place to talk about perjury. All right, so we only get half an hour lunch. We're going to take a break. I'm going to build a portal. We're going to come back and continue the all important tree and fence case. I'm sure the judge is just popping Excedrin right now, just getting ready to deal with how this is going to go down.
Remember in the beginning when we started 110 years ago?
Oh man, it's awesome. Continuing my trial of what I need to do differently on my channel to make it safe from YouTube strikes for content that violates terms of service. I have changed the because this is a current event, something that's happening immediately, and it's in the public, as all court cases are. I've put this in the news category. Honestly, it's news or politics. So we changed our channel to be news and politics. It is clear to me that that it puts us lower in the algorithm for referrals. We've had maybe 500 or 600 people here, sort of on a good moment, even if we have some spicy stuff. So we get a lot fewer people in chat, but it might, yeah, I don't know. I just don't know what else to do. We're following court cases that have firearms in them, and if the prosecution or defense decides to exhibit the firearm and hold it in their hands, suddenly we have the potential of just being zapped instantly, like Trial TV Live got today, and Cat Not Williams got for the same reason. Ryan Hall mentioned good things coming for people who watch on TV and comment on phone. Have you heard about it? Mary, I don't know. Is it talking about his channel? Has it got good weather coming or what? Yeah, it might preserve our right to broadcast its live court proceedings. So, yeah, it's my only concern is if it's not sustainable financially, I can't continue it in the long run. So I'm trying to figure this one out. If you guys hear anything from other channels that are fighting this same fight, please let me know. I'm trying to put all the information together. There's very limited information available to us, and that our appeals for contacts to a real human are apparently not having any effect. So that would be cool. All right, let's build a portal really quickly, shall we? Give me a second. I told you I'd build a portal. Let's do that. Schedule. It's going to be... It's the tree and fence case, part 2. When did he say we're coming back? In half an hour? Yeah, we're going to be gone half an hour. That's going to be 2:15. I'll say 2:15. We'll probably be back a little sooner than that, but we'll do it. Enid, Oklahoma got decimated by tornadoes. I know. And a huge shout out to Emily D. Baker. Made a huge pledge for people in that area to help. Sloth Life, I saw you were first. Sorry, hang on a second. There we go. Let's see, pin message. Go back, make the link. But yeah, she made a $15,000 pledge to help people affected by that tornado in her neck of the woods. So, way to go, Emily. That's awesome. Okay, hold on. Making the portal still. I'm slow at this one today, guys. It's Friday. I'm winding down for the work week a little bit. There we go. That's the wrong one. That's the birthday song. You don't get that twice. There we go. Next week we have 2 cases. Well, next week we have 1 case, and the week after we have another case out of Ohio. There are going to be some good ones. Just had a ruling from the judge in the Caleb Flynn trial that the jury will be going to do a site visit at the home of the former American Idol contestant, Caleb Flynn. So that's going to happen. There's going to be a jury view in that. All right, we'll see you on the flip side. We're going to be back in about half an hour. So eat quickly and then return to your seats promptly so we don't miss anything out of Judge McBurney's trial. The tree and fence trial. It's the one you didn't know you needed to see. Most of us have problems with neighbors at one point in our life or another. You'll need this information at some point. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better. And please stay safe till we go live again in about half an hour. Jump in the portal. You can continue having the conversation on the other side with all your friends. And we'll see you guys in just a little bit. Thanks a lot. Bye-bye.
Banished from the state of Georgia.